Mhm. Okay, so it's 1 o'clock now.
I am expecting everybody, and I see Mark. Mark, can we hear you this time? I'm hoping we can hear him this time.
Can you hear me now?
Yes, yay. Thank you.
So I see Jeff, myself, Lisa, Mark.
Yeah, Mark, we can hear you. We are live, FYI.
Yep, I'm just waiting to see the rest of our board members get on before I call it to order. I don't think we have Jeff, Michael.
Good afternoon.
Mark, Kieran, myself, Lisa. Who are we missing? Just Jim?
We're missing Jim and Ed. Jim and Ed.
Okay, we'll give them another minute and then I'll call it to order.
Just an FYI, I'm assuming we will go, but at this point, I'm planning to be traveling on the 10th of December.
Okay, we are meeting on the 10th. So.
I know, I just noticed that, and and I'll be, I think I land in Logan at 2:30 or something.
So you're unlikely to be able to.
I'm unlikely to be able to be there.
Okay.
Double check.
Well, in that event, we should probably have you not sit on the Summer Street application in the event that.
Okay.
Mm-hmm.
Let me just double check. Yeah, Thursday, December 10th, I land at 2. So
hold on 1 second. Ed's just calling me. Yeah, leave and come back in because I don't even see you. Hold on, let me just look and see if I can. Bear with me, everyone, for a minute. Let's see. Peter. All right, Ed Toole, I see you here. You're under an attendee, not a panelist. Did you register? Okay, so hold on, let me just see if we can get someone to fix this. So Ed is on the phone, he can hear us and see us, but we can't hear or see him. He's listed as an attendee, not a panelist, although he registered. So Eleanor or NCTV, or I don't know who else.
Mark, who's NCTV, I'm talking to you now. I gave you his name on that list. Did you not send him the email that we all got, which gave us our own personal logon?
Who are you referring to specifically?
Ed Toole. He was on the list I sent you yesterday. So he's a member of the ZBA. He definitely needs to be a panelist.
No, I can't see you because I think you are a panelist. So an attendee. Can we just change his credentials, whoever has that authority, whoever's a host, from attendee?
I don't seem to have the ability to do that because of where he is. Maybe Mark can do that.
Hold on 1 second. I did send Ed the email, but I'm going to resend it again.
Okay, so Ed, you'll get an email, and it's really simple. You'll just hit the link, and it'll launch you into the panelist panel.
All right, so maybe just log out and try to log back in again. Okay, all right, bye.
Sorry, I don't know.
Okay, so he's going to try to get back in. Do we want to wait a second or do you want me to call it to order?
That's up to you. I mean, I think you can read your preamble now.
Oh yeah, I'll just start doing that. Okay. Good Lord. Okay. All right, bear with me because there's 4 pages here. The ZBA script for remotely conducted open meetings. There are new public participation guidelines. We are now using Zoom webinar for meetings. This allows for the public to participate in the meeting as an attendee. Attendees must register to participate. The registration link is unique to each meeting. The registration link can be found in the description of the Nantucket Government TV YouTube live feed for the meeting. People registering to be an attendee must use their names, otherwise they will not be allowed to participate in discussion. Attendees will join in listening mode. They can click the raise hand button if they wish to speak. The chair will call on those who have raised their hands in the order they were raised. So that's me. So I will call on you when it's your turn to speak. YouTube chat is no longer going to be enabled, and all questions should be directed through me. As a preliminary matter, my name is Susan McCarthy. I'm the chair of the Nantucket Zoning Board of Appeals. Please permit me to confirm that all members and persons anticipated on the agenda are present and can hear me. So members, when I call your name, please respond in the affirmative. Lisa Botticelli.
Here.
Michael O'Mara.
Here.
Kiram Kosayatak.
Here.
Jeff Thayer.
Here.
Mark Poor.
Here.
Mondani.
Here.
Staff, when I call your name, please respond in the affirmative. Eleanor Antonietti.
Here.
Paul Murphy.
Here.
Okay. And Alexander Weishit.
Here.
Is that the right pronunciation?
Weissite.
Weishit. Okay. Sorry. Thank you.
No, that's all right.
Okay. So next are the anticipated speakers on the agenda. Please respond in the affirmative. And some of these people may not have logged in right now, or they may log in later. And there may be other people that log in later who are not on this list. So it's not all inclusive. Dan Bailey, attorney for application number 20-20.
Here.
Danielle De Benedictis, co-counsel for application 20-20. Joel Quick, co-counsel for application number 20-20.
Here.
Peter Kyberg, attorney for owner 1-3 Reed's Way.
Here.
Michael Reed, owner 1 and 3 Reed's Way.
Here.
Linda Williams, advocate for owner 1 and 3 Reed's Way.
Here.
Drew and Jessica Guff, co-appellant in application number 20-20. Edward and Marilyn Gregory, co-appellant in application number 20-20.
Here.
John and Tracy B. Flannery, co-appellant in application 20-20.
Here.
Peter and Linda Hoey, interested in application number 20-20.
Here.
Scott Thomas, resident of Tom Nevers, interested in application number 20-20. Terry Eichler, 11 Old Westmore Farm, interested in application number 20-20. Randy Ringer, owner of 3 Chuck Hollow Road, interested in app number 20-20. Gordon and Gretchen Cooney, 65 Winoma Way, interested in application 20-20.
Randy, Randy is here, by the way. He just,
Yes.
Oh,
Sorry.
okay.
Yep, thank you.
Okay, thank you. Sorry, so Gordon and Gretchen Cooney of 65 Winoma Way.
Here.
Okay. Liza Otani, resident of Tom Nevers, interested in application 20-20. Marianne Hanley, attorney for applications numbers 24-20 and 25-20. Linda Yates, owner and applicant of 21 Derrymore.
Here.
Thank you. And Ethan Griffin, architect for 3 Summer Street project.
Here.
Thought I saw, okay, thanks Ethan. And Gunnar Wilmot, owner of 3 Summer Street. Okay.
Susan, I did get in.
Oh, good. Okay, great. So Ed Toole is present. Okay. This open meeting of the Zoning Board of Appeals is being conducted remotely consistent with Governor Baker's executive order of March 12th, 2020, due to the current state of emergency in the Commonwealth due to the outbreak of the COVID-19 virus. In order to mitigate the transmission of the COVID-19 virus, we have been advised and directed by the Commonwealth to suspend public gatherings. And as such, the governor's order suspends the requirement of the open meeting law to have all meetings in a publicly accessible physical location. Further, all members of public bodies are allowed and encouraged to participate remotely. The order, which you can find posted with the agenda materials for this meeting, allows public bodies to meet entirely remotely so long as reasonable public access is afforded so that the public can follow along with the deliberations of the meeting. Ensuring public access does not ensure public participation unless such participation is required by law. This meeting will feature public comment as previously noted. For this meeting, the Zoning Board of Appeals is convening by the video conference via Zoom app, as posted on the town's website identifying how the public may join. Please note that the meeting is being recorded and that all attendees are participating by video conference. Accordingly, please be aware that other people may be able to see you and take care not to screen share your computer. Anything that you broadcast may be captured by the recording. All supporting materials that have been provided to members of this body are available on the town's website unless otherwise noted. The public is encouraged to follow along using the posted agenda unless I say differently and we change it around. We are now turning to the first item on the agenda. Before we do so, permit me to cover some ground rules for effective and clear conduct of our business and to ensure accurate meeting minutes. I will introduce each speaker on the agenda. After they conclude their remarks, I will go down the line of members, inviting each by name to provide any comment, questions, or motions. Please hold until your name is called. Please remember to mute your phone or computer when you are not speaking, and please remember to speak clearly in a way that helps generate accurate minutes. For any response, please wait until I yield the floor to you and state your name before speaking, please. And if members of the board wish to engage in a conversation with other members, please try to do so through me, taking care to introduce yourself or identify yourself so it just keeps in an orderly fashion. And each vote that we take today will be taken by roll call. Okay, so I think that covers that part of it. So let's call this meeting to order. And does someone want to make a motion to approve the agenda?
So moved.
Who was that, Karen?
Yes.
Okay.
I will second it.
Okay, so the motion's been made and seconded. I'm just going to go down the list. Lisa Botticelli,
Aye.
Ed Toole,
Aye.
Michael O'Mara,
Aye.
Karen Kosayatak,
Aye.
and Jeff Thayer.
Aye.
Okay, so that the agenda is approved. So the first thing is the approval of the minutes from October 15th, 2020. I read them over. I did not have any comment. Lisa, there's 2 matters on there, I think, that you served as chair for. Did you have any comments on those?
Nope. Nope.
Okay. Did any other member of the board have any comments or corrections on the minutes from October 15th? No. Okay. Do we, Ed, did you have any comments on those? No. Okay. Okay. So would someone want to make the motion to approve the minutes as proposed?
I will make that motion.
Okay.
Second.
Okay. So motion's been made in second. I'm going to go through again. All those when your name is called, if you're in favor, say aye. Lisa Botticelli.
Aye.
Ed Toole.
Aye.
Michael O'Mara.
Aye.
Karen Kosayatak.
Aye.
And Jeff Thayer.
Aye.
Okay. So those minutes are approved. Okay. So moving to our first matter of old business, we have application 20-20 Drew and Jessica Guff, DJG Associated LLC, Edward and Marilyn Gregory et al. Appellants, 1 and 3 Reed's Way. Attorney Bailey presenting. And Attorney Bailey, I'll give you the floor.
My co-counsel and my client are having trouble getting in, navigating the webinar.
Okay.
Danielle, you're not in yet, are you?
Let me just see. They are. So
see her.
I have Drew Guff twice under attendees, but not on a panelist. So I don't, is the distinction that, and Mark, I guess, Nantucket TV, this is a question for you. Is the distinction if someone is an attendee, they cannot be heard?
The attendees, they can be heard, but they have to raise their hand and you have to access it as a co-host.
Okay, so I don't have any, there are no hand, actually there's a hand up now. So then
You allow them to talk.
Well, I only have a thing to chat for him to type a message.
Okay, well, Eleanor's the co-host unless you want to be made co-host. And then you'll have that privilege.
Oh, now
I'm
it says
co-host.
talking.
I just unmuted him. He should be able to
Can you
talk.
hear me now?
Yes.
Hi, it's Drew.
Okay, so he's here. I see Danielle, or I saw Danielle.
I see Danielle, but she's muted. Do you need to unmute her?
Oh, yeah. Someone
Chair?
just unmuted me, so if you could unmute her also, I guess that could work.
I can only ask to unmute, which I just did. She has to do it on her end.
Yeah, so here's the deal. I don't want to have everybody unmuting who's on this application. I only want the person unmuting who's speaking. So, yeah, so Attorney Dan Bailey can unmute so he can present. whatever.
I intend to present.
I know Danielle. So when he's done, then we'll move to the next person, but I don't want people talking over each other. So everyone will just unmute when it's their turn to talk.
Got it.
And
Got it.
Whatever, Dan, you don't have to go first if Danielle wants to go first.
Yeah, Danielle will go first and I'll go on mute.
Okay. Just one more thing, sorry, before we get going on that. There was an issue raised between last meeting and this meeting about one of our board members having a potential conflict. The conflict was disclosed at the beginning of the initial hearing, and no one had an issue with it. But since then, an issue has come up. So Ed Toole has said he will recuse himself because of the potential perceived conflict, although I don't, he disclosed, and I have full faith and confidence in his ability to make an objective decision. That said, it's been made clear that it would be an issue or could be an issue for an appeal. And so he has made the decision to recuse himself from this.
Madam
That's-
Chair, can I make a suggestion?
Yes.
I think it would make sense to name one of the alternate members who would be voting in his place. Perhaps it would be best for the normal voting members to hold a vote to authorize one of the alternate members to vote in his stead.
Well, I don't think we have to do that yet, do we? Because my understanding was that everyone can sit on any application, not just this one, that everyone can sit, participate in the discussion, and then we decide when we are voting, we decide who's voting. So I think
Certainly,
we have enough people that does that make sense?
That's fine, sure. Yep.
Okay. So as far as, okay, Ed, you want to speak? Go.
Well, I just wanted to talk about the perceived conflict a little bit and ask the appellant whether or not what their opinion, well, and or town council, what their opinion of the perceived conflict was. Is there a perceived, I mean, I don't even know what a perceived conflict is. There is either a conflict or there's not a conflict. So does that make any sense? To have that discussion?
I think it makes sense. I mean, I'm using the word perceived conflict because there was no conflict. You disclosed, and then in between the two hearings, the owner of 1 and 3 Reed's Way made it apparent that they believe there is a conflict, and so.
Well, and I think they labeled it a perceived conflict. So I'm not putting those words in your mouth. I think they're.
Yeah, Madam Chair, I'm glad to offer my 2 cents on this, if that would be
Thank you.
helpful. So I would agree with you, Madam Chair, that this is not an actual conflict of interest. It is at most a perceived conflict of interest, meaning that it's really up to Mr. Toole whether or not he believes that he can remain impartial here. I also would recommend that to the extent he decides to vote on this matter, that he file a written disclosure of the conflict with his appointing authority. So that would be the select board. I don't know if that's happened yet or not.
Yeah, I don't.
I didn't file that form.
Okay.
So again, I just didn't like how this all happened. I did disclose. I listened to the tape. Was it maybe as deep? You know, there could have, I suppose, been additional details, but there was no discussion took place. No one asked me a question. I would have answered any questions. I just feel that at a certain, or I feel like the whole thing has been, does my participation even in the first portion of this hearing sort of queer the deal, if you will?
No.
Okay. So if I recuse now versus later, well, not later, versus continuing, is the slate cleaner, if you will?
In my opinion, that would moot the issue on appeal.
The recusal.
Correct.
Okay. Well, then, if it moots the question on appeal, it's probably, well, Susan, through you, does it make any sense to talk to the appellant as to whether or not they believe there was a conflict?
Yeah, so I'm sorry, I just want to clarify, when you said it moots the issue on appeal, just, can you flesh that out for me for a second? I didn't follow that thread.
Sure. So to the extent that any challenging party is raising an issue about this conflict of interest, if Mr. Toole does not ultimately vote on the application, then I don't think that the conflict of interest should be a live issue or something that will be addressed in court on a future appeal.
So he can continue to participate. He just wouldn't be one of the 5 members voting.
Well, if he's going to recuse himself, I would recommend that he probably stop participating at this point.
Right. But you're saying if he doesn't recuse himself, if he doesn't vote on it, there's no, if the decision then was appealed, his participation would not be grounds for an appeal.
I'm sorry, I don't think I followed you.
So the question is, right? So the appeal, the conflict was disclosed at point A.
Right.
We did a whole meeting, and then between that meeting and this meeting, it came about that the Reed's Way feels that Mr. Toole has a conflict because of his, parents or mom's involvement in that property 20 years ago, or even sooner, whatever they believe the conflict is. If that, to raise it now after there's been discussion and certain opinions have been out there, it seems like it's laying the groundwork for an appeal if Mr. Toole doesn't recuse himself.
So, well, I anticipate there will be an appeal no matter what the decision is of the board. I think to the extent that he recuses himself, then it should not be an issue that's raised.
May I ask a question?
Yes, Mr. Guff.
Because appellant was mentioned. The attorney Weisheit mentioned at the beginning that there is not a conflict. There might only be a perceived conflict. So I just want to ask if you're talking and that it's Mr. Toole's choice to recuse himself or not, since there is no actual conflict, there's only a question of perceived conflict. So if we're talking about conflict, I just want to separate between there is no conflict and Mr. Toole's choice as to whether he wants to participate or recuse out of perceived conflict.
Right. Attorney Bailey, do you have any, or Danielle De Benedictis, do you have any opinion about Mr. Toole's continued participation?
Can you hear me, Susan?
Yes, I can. Thank you.
Under the Massachusetts Conflict of Interest statute, there is no conflict here. That's absolute black letter law. He'd have to have a financial interest. And also, if you go down to section 19 of 268A, which is the Massachusetts Conflict of Interest statute, even if he had a financial interest, if the question was one that was going to set general policy, which clearly this one is, even somebody with a financial interest could participate. So I consider this to be a red herring, and I would consider it a ground for appeal for us that Mr. Toole was somehow forced into recusing himself.
Okay, so.
Can I speak, Susan, briefly? Michael Reed?
Sure.
It's just there's new information. I think Mr. Toole said at the last meeting his family owned the land across the street. And the new information is that it was actually Mr. Toole that sold 2 lots for huge prices to Mr. Gregory very recently. And Mr. Gregory's a direct applicant. And Mr. Toole's family litigated the same matter all the way to the Superior Court 20 years ago. So that information was not disclosed last meeting. It's something my legal counsel uncovered. So I think that new information is very relevant, and it's a direct conflict, in my opinion.
Okay, thank you. So,
Ed, Mr. Toole, Mr. Reed is not an attorney, and we have to view these things according to the Massachusetts Conflict of Interest Statute, General Laws, Chapter 268A, Section 19, which requires him to have a present financial interest, and he has none. And when he sold, quote unquote, sold these two pieces of property, he did so as a trustee. And so it's not apparent from the record that he had a financial interest at any point in time. And certainly what somebody's mother or brother or sister did 20 years ago should have no binding effect on this board. With so many longstanding families in Nantucket, that would make everybody ineligible to sit on anything.
Yeah. Okay. Thank you, Danielle, for clarifying that. So, so Ed, I guess it's really up to you. I know you were ready to recuse if that was going to be what would be best for this application and the board and going forward. But it seems like it's really up to you for your comfort level, because as town council said, there's no direct conflict here.
As long as town council seems to say that there is no real conflict, I don't feel there's a conflict. I thought that Attorney Kyberg's letter of reasoning that there might be a conflict was not very, there weren't strong arguments, but I don't want to, I guess it's more to the rest of the board as well. I don't want to muck things up if, I mean, I don't know where to go with this one, frankly.
I mean, Ed, you've been the chair of this board. You've sat on this board longer than most of the other members, with maybe Michael Lemaire as the exception. So, I mean, I don't have any doubts of your ability to decide this objectively. So, and all of these events are in the past. I don't see that you have, town council's telling us we don't have a conflict. So I definitely think you want to file the 2-liner disclosure form.
Yes, agreed.
But other than that, I think it's your comfort level. And that said, you may not even be voting on this. Like, we'll see where we end up when we actually take a vote. So.
Right. Is filing the form several days later, is that an issue?
Ideally, you would file it before you vote. It could be an issue. I don't think it would be, but.
Well, again, I'm not saying any, it's more, will it just create another layer of problems? It's not.
No, it's way better I think it's better to file the form. And I also think, and town council can either back me up or not, but because we're discussing this disclosure now, and you did disclose it at the initial meeting and no one had an issue with it.
Madam Chairman, I'm sorry, but that's not the case, though. He didn't disclose all the grounds that we have for suggesting that he may want to recuse himself. And it is not an actual conflict. And we would agree with that. If you were a member of the public who's watched these zoning board hearings for a couple of decades, it would jump off the page at you that his family was part and parcel of the same litigation for the same property for the same exact reason. His family was part and parcel of that as longstanding abutters. And yes, he disclosed something at the beginning of last meeting, but respectfully, he didn't disclose whether or not he had a beneficiary interest in the land. He still hasn't disclosed that, although we have reason to believe he did have a beneficiary interest of the land that was sold. And moreover, as I said, this longstanding dispute between my clients and the neighbors goes back 20 years, and the Toole family was clearly involved in that and clearly fought on the other side. And if you were a member of the public, you would say, wait a minute, that's the Tooles. They already weighed in on this. In other words, I would suggest a member of the public would think that you're not starting off from an objective position, respectfully.
But that's not our standard, I don't think. And it wasn't Ed, it was his a generation before him. And I get what you're saying, but I feel like this is all, I mean, it was on the page that we had that his family member was a party to it. I don't know. I mean,
Susan, can I ask Peter a question?
Sure.
Peter, I'm curious, why didn't you ask me any questions at the first hearing when I did disclose that my family was an owner and therefore had a financial interest in the property at some point? They did not have any, none of my siblings, my mother, my father, both of whom are deceased now, had no interest in that property at this point. Why didn't you ask me any questions at that point?
Well, there's a lot I didn't know at that point, and took your statement at face value. Having known you for a long time, there's no reason why I wouldn't have done that.
But he didn't say anything that was improper.
Right. And again, it's not that he wasn't holding back that he had a financial interest or an ongoing financial interest. I mean, he disclosed what he thought might be perceived as someone might feel uncomfortable with. Nobody did. So we moved forward. So
Listen, it's his choice. I don't dispute that. It's absolutely his choice, and let the chips fall where they may. I don't know what my client's going to do about it in the long run. If Ed does vote on it and it has a meaningful role. So it's up to Ed, and we know that. And then let the chips fall where they may.
Well, if I could just briefly, again, my big issue is that it was Mr. Toole, not his parents, that sold 13 and 15 Sandsbury, the abutters, to Mr. Gregory, who's a direct applicant in this matter. And this wasn't brought up in the last hearing. So it wasn't just his parents owned the land. To my knowledge, his parents deceased. He sold the land of trustee to a direct applicant in this matter, which to me is, I mean, I'm a layperson, but it appears to be a conflict.
I've had my hand up for a few minutes.
Well, I'm sorry. First of all, Mr. Gregory, I apologize. I can't see.
Okay.
I don't see hands up. So I just want to, technically, I guess I need to.
I've been mentioned here and it sounds nefarious. So if I might just say two things, please.
Okay. Well, just give me a second, please.
Okay. I'm sorry.
Susan, I'll help you. I'll keep an eye on the hands up and let you know. It's a lot to run.
Because there's two different categories. So this is a lot. It's kind of a lot to manage because I'm looking at all of your faces, and then there's also a tab of panelists and a tab of attendees, and then that has to come up on my screen. So
I'll keep an eye on it for you.
Okay, because it looks to me like there's, I don't know, Mr. Gregory is the only one right now with his hand up. Okay, so just, I want everyone to just pump the brakes for a second. So the fact that the estate or whatever sold property to an appellant, I don't think that counts as there's not an active financial interest. And I don't believe that Mr. Toole's time as executor or personal representative, whatever, that they had filed any complaints or were at all involved in that. So I'm going to let Mr. Gregory speak. I'm probably going to go back to town council, and then we're going to let Ed make his decision, and then we're going to move on. Okay. So Mr. Gregory, you have the floor.
Thank you. Just so you know, I have never met Ed Toole. I never met anyone in the Toole family. I found out the property was for sale. I didn't know who the seller was until I got the closing documents. I worked through 2 real estate agents. I purchased both pieces in LLCs for reasons I don't need to share. I think everybody can understand that. It was only ever my reason to purchase them was that the hillside above looms over my property now, and I purchased them in order to maintain my privacy. And I wasn't even aware that Mr. Toole was on this board until the last meeting. and I didn't realize that it was the same family. So to suggest anything else is unfair and misleading. And that's all I really need to assure everybody. And I would happily say that under oath.
Okay, thank you. And then Alex, did you have anything that you wanted to add to this before we?
No, Madam Chair, I think ultimately, again, it's back to Mr. Toole and what he's comfortable with here, because ultimately, even if, if there were an issue that could be argued to rise to the level of a conflict, which I think we all agree is unlikely, then it would be him who would have to deal with the issues at the State Ethics Commission. I don't think that his participation would, ultimately deal in a court overturning the board's decision, in my opinion.
Okay.
So, can I speak to Alex about this specifically?
Yes. Yeah, totally.
Okay, just to be totally clear, at the hearing, when everybody was there, I said that the family had an interest. We don't anymore, and because it was sold, so is that enough? You just said something to the effect that I could get in trouble with the ethics board. I'm not that interested in that.
Only if whoever appealed to the ethics board were able to prove that you have an actual conflict.
All right, and okay, so fair enough. So what constitutes a conflict today? I don't have any. Go ahead.
Active financial interest.
Okay. Because I have no financial interest in this property and haven't. I don't remember when. First of all, it was my family that sold the property. 3 of my siblings were co-owners. It wasn't just me. I just happened to be the lucky winner who dealt with the paperwork and whatnot. But I don't remember even when I sold this property to Mr. Gregory. And as he said, we've never met. I wouldn't know him walking down the street. So I don't feel that there's a conflict, but I want town council to tell me that I don't have,
No,
I'm not going to be dealing with this, or otherwise I'll just recuse.
So I do not think you have an actual conflict, but I can't guarantee that one of the interested parties wouldn't raise this issue with the State Ethics Commission. That's beyond my control, unfortunately.
Is in your opinion, is the lack of granular detail at my first at the first hearing when I disclosed, is that grounds for an ethics violation?
Unlikely.
Okay. But possible. Everything's possible.
Anything's possible.
Yeah, I know. Okay.
But again, I think I would strongly recommend filing the disclosure form with the select board.
Well, with that in mind, can we simply, if I decide not to recuse, can we simply postpone any vote until I have filed the form?
Certainly, as long as we're within the 100 days of when the application was filed.
Madam Chairman, might I have 2 cents here very quickly? I don't know how to raise my hand.
Linda, I'll give you like 45 seconds, then we're going to let Ed make his decision because we got to move on.
Having been involved with town boards for 37 years, I have speed dial ethics commission. I've had actual and perceived. There is actual, which we've all agreed Ed doesn't have any ongoing current financial involvement. However, a lot of what's happened on HDC and other boards have been perceived conflict. As a reasonable member of the public, as they stated in the letter, might assume there is a perceived conflict, which is why it was brought up. The full details of the involvement and the family involvement with the original decisions and appeals brought 20 years ago, which I was involved with, were not completely known by Peter Kyberg at that time until we got a full copy of both files. And then it became rather concerned that his family, his parents, were involved with the original action against a previous predecessor in title, Bob Elliott, who was a little out of control out there. We all admit that. But it's just a perception of conflict, which is in the state ethics laws, because I've had to deal with that before. So I just don't want to get trapped in here about the only thing that the Ethics Commission looks at is actual. They also look at perceived, and we still state that there is a perceived conflict. So I've gotten off things when I have a perceived conflict. It's up to Ed entirely. Nobody can tell Ed what to do except for the Ethics Commission, not town council, not me, not you. Ed has to make that decision on his own. So
Exactly.
leave it up to Ed.
Okay.
But I would caution not to sit on it, but that's our position.
Madam
Okay.
Chair,
Thank you, Linda. Who was that? I didn't see who that
Michael
was.
O'Mara.
Oh, hey, Michael.
Could I have 45 seconds?
Sure.
As everyone on the board is aware, Ed Toole has raised the bar as far as the standards for ethics is concerned, as well as truth and veracity. My advice to him right now would be don't sit on this application.
Welcome to the meeting, Ed.
Yeah. Glad to be back. All right. I think there's enough of a gray area, although Alex, I'll ask you one more time. I mean, Linda, who I don't think is an attorney, and I tried to call the ethics committee yesterday, or commission, but realizing it was not real. I didn't realize it was Veterans Day at the time, so I didn't bother, figuring they were closed. So having said that, and I think I asked this already, is there such a thing as a perceived conflict?
There is, but if you were to file a disclosure form, I think it would make the argument that you have a perceived conflict an unreasonable one.
Okay, so
All right.
it's up to you.
I guess at the end of the day, I will take the advice of the elder statesman of the board, Mr. O'Mara, and let my other the other board members who I have full confidence in deal with this issue. So I will recuse at this point.
Okay.
Okay.
Okay. So then we will moving forward. So Danielle, I believe you were going to present first on this.
Okay. I want to make the point, as I've made in my written documents, that contrary to what has been asserted here, residence alone is not the determinative factor as to whether or not an activity is commercial and can be considered commercial in a residential zone. And that's been made clear by all of the cases which have been determined in this area. And I've set forth all of this in a PowerPoint for everybody's consideration. And I'd like Ms. Antonietti, if she can, to pull up that PowerPoint too right now. It's at page 27 of your package.
Isn't the PowerPoint?
It's not on page 27 of my packet.
I think it's at the end. Sorry, I think it's at the end of the staff report, actually.
Oh, thank you. Okay, hold on.
Yeah.
Thank you.
Yep.
Can you see it now, everybody?
Just give me a moment, please.
Oh, of course, thank you.
Danielle, is that your dog in the background?
Yes.
What?
Try to quieter.
No, it's fine. I was just going to say, if it's someone else's dog, mute it while you're trying to present. But if it's your dog.
Somebody must be coming to my door, and that's when she barks.
Can you see the PowerPoint? I have it up on my screen as far as I know.
Yeah, I can see it.
Thank you.
So I would like to speak to these factors. As for whether or not Whales Watch is advertised as a commercial wedding and event venue to the general public, we submitted to you at the last hearing a plethora of advertisements in which Mr. Reed is actively and aggressively advertising Whales Watch as a wedding and event and hotel venue. Those advertisements have gone so far on the internet that Nantucket has picked it up in their GPS maps and put a hotel icon at 1-3 Reed's Way. And so it's very clear that one of the primary factors that the other courts have looked to, not just Bourne, but D. Giovanni, which was and DeBoro, which was a Supreme Judicial Court case, was whether or not there was advertising. Here it's indisputable. There is very aggressive advertising. And here I'd like to bring in the fact that this recent submittal by Mr. Kyberg, going back to what happened 20 years ago, Jack Dunn in his 11/20/1998 letter said that the reason he was finding that Elliott's use of the property was not commercial is that Elliott did not advertise. So here I feel that the earlier submittal clearly supports our position here. And Jack Dunn's second factor, which is the second factor here on the PowerPoint, whether or not events are for people unrelated to the owner. That was the second thing that Jack Dunn mentioned in his 11/20/1998 letter. He said Elliott, the events he was having there were for his family and friends. And so clearly we meet these criteria in the instant case. And Jack Dunn used the non-meeting of those criteria by Elliott to distinguish. So I would say that Jack Dunn's letter supports our position that Mr. Reed is operating this as a commercial venture. And then if you go on to the next factor, whether the owner resides on the property during the events. Well, the owner here clearly, Mr. Reed says he doesn't reside in the property during the events. He says that everywhere. And I don't think he would dispute that here. And so therefore that's another non-issue. Whether the events are hosted for monetary profit. Mr. Reed is clearly hosting these events for monetary profit. He advertises how much he charges. It's in his contract. He's charging $40,000 a week. He's letting people book a room by the night. He's doing this for monetary profit, unlike Elliott, who is doing it for friends and family. So again, I think the new quote unquote evidence by Mr. Kyberg is actually in our favor. And then you go to the next criteria, distinct nature of the event use. And here, I'd like to read to you from the Di Giovanni case, and it says, because a dominant rental and marketing of the property would stress that it was set up and available for the holding of big weddings and other large, well-attended social gatherings was not minor in significance and subordinate to the primary use of the property, which is for a single family residential use. The intensity and frequency of the use of the locus took this use beyond a mere accessory use and transferred it into a primary use. That's exactly what's been done here. And if you look at the large chart of when these events are taking place that was submitted by Mr. Reed recently, I'd have to note that none of Mr. Reed's submittals are under oath. Unlike the submittals that came in on the Westmore Farms case, where, you know, unfortunately, I think that Commissioner Murphy was either unaware of those submittals or didn't think to look at them. But here, there's a very important distinction. Mr. Piles said under oath that he was living at the property for a good portion of the time whenever the events weren't being held. Mr. Reed has submitted the same thing to you, but never under oath, which I think is an important distinction. Furthermore, with respect to the Westmore property, it was very, very clear from the advertising of the Westmore property, which is also on the internet and was in your ZBA packet. It never went as far as you, but it was before Commissioner Murphy. It was very clear that all that advertising that was being done by Westmore Farms, which was for events that were exactly the same size as this, 300 to 400 people. In Westmore Farms was advertising it could sleep 22. Mr. Reed advertises he can sleep 40. I submit to you that these two locales are exactly the same. Both owners are saying they live there, one under oath, and that they live there, but they don't live there while the events are in process. And both owners are aggressively advertising the property for 300 to 400 people and for overnight residents. I think at the last hearing, Mr. Murphy, when I was arguing that there was no distinction between the properties, tried to make the distinction that people didn't stay overnight at the Westmore Farms property. That's belied by the entire record before the board in the Westmore Farms case, and certainly was belied by the very aggressive testimony by the neighbor, Terry Eichler, that just urged you, if you do anything, please don't accept any testimony that people weren't staying there overnight. They were staying there overnight constantly. So again, I see no distinction whatsoever between the Westmore Farms property and the Whales Watch property. And I think that a decision that would support shutting down one while letting the other continue would be considered by an appellate court to be arbitrary and capricious, as well as wrong as a matter of law. And with respect to the remaining criteria, the ability to continue for profit residential use. This is something else that the courts look to. Mr. Reed, if we are successful in this appeal, can continue to rent his property as a residential property for rent to people who are going to use it as a residence, which is the way it should be rented because it's in a residential zone. And this was something that the courts looked to in the cases in this area. In the Dia Giovanni case, the court said this decision, which does not prohibit plaintiffs from renting their property as is customary, but which does prohibit plaintiffs from marketing and renting their property for the purpose of having these renters host large gatherings and weddings, is entitled to be sustained by the court. And that was our appellate court by which you are bound. And whether or not this use is typically conducted as a business, marketing in a property as a wedding and event venue is a business. It's completely different than marketing your property as a residence. And we're not asking for Mr. Reed not to be able to continue to offer his property for rent on VBRO and through brokers or wherever else he wants to people who are going to use it as a residence. That's what it's supposed to be used for, both by the owner and by anyone else he lets stand in his shoes and occupy that property. And when we get to the use of surrounding properties by comparison, I don't have to tell you that all the other residents in the area are single family residents. This is a residential lug 3 zone. And I don't need to belabor the point that the noise impacts the surrounding properties and traffic and parking impacts the surrounding properties. Those points are axiomatic. And as for the number of events held, in the Di Giovanni case, where the court said that the activity was clearly commercial, there were only 5 events during a single season. Mr. Guff testified that on the week of September 12th alone, he gave eyewitness testimony showing that there were 6 events during that 1 week alone. So many, many more events, and I would say this is supported by the grid recently filed by Mr. Reed, are being conducted in this property. Just because somebody rents the property to hold a wedding for a certain week doesn't mean they're having one event. As the neighbors have testified, it's an event every night of that week. And you'll be hearing from another neighbor, Wendy Conway Schmidt, who's herself a lawyer who lives 1.5 miles away from the property and rents her own house. And she said she would never allow the rental of her house as a wedding or an event place because she knows it's forbidden by law and because she wouldn't want to disturb the neighbors, and that at 1.5 miles away, she can't even use her property when she's in residence there when Mr. Reed is having events. So I won't put words in her mouth. You can hear from her. And then when it gets down to the number of people attending events, 300 to 400 people are solicited to attend these events by Mr. Reed. And that's exactly the number that was solicited by Mr. Piles. So why again was Mr. Piles shut down and Mr. Reed allowed to operate? I believe that on appeal, that's completely not sustainable. And as far as Westmore Farms having a barn, Mr. Reed actively advertises that he can accommodate 74 people in his inside great room. So again, I see no distinction there. The building inspector had no trouble issuing a cease and desist order against Westmore Farms. I urge you not to have any problems in overturning his decision in Wales Watch. The use of this property as a venue for weddings or other large gatherings by unrelated third parties on a rental basis is not accessory to its permitted residential use. That's a direct quote from Stevens v. Bourne, and I will now pass the mantle, so to speak, to my co-counsel, Mr. Bailey, who is an expert in zoning law and can give you a little more color to the criteria the courts have set forth in determining whether or not a use is accessory and permitted in a residential area. And I thank you for giving me the opportunity to speak here.
Thank you, Danielle. I just want to point out a couple of things with respect to Danielle's presentation. The letter from Mr. Dunn that she referenced is at page 83 of the ZBA packet. There is also a letter from Mr. Elliott at page 56 of the ZBA packet. That letter from Mr. Dunn says quite specifically that the reason that he's not going to enforce is because Elliott is just using the property for friends and family. And the letter from Mr. Elliott says quite specifically that he is not advertising his property for events. So Danielle's talked about the legal factors that the courts have considered in determining whether a use is accessory. You know, I want to go into that a little bit more, but I also want to start by saying at the last hearing, I think some members of the board expressed the view that, you know, your decision is not really decided by court cases. Instead, it's a matter of determining what accessory uses are customary on Nantucket. And I'll agree with you that what is considered accessory in Nantucket may differ from what is considered accessory in another community. Every community is different, and the law is clear that each community is free to interpret what is customary on their own. But I don't agree that the board does not have to consider well-established case law in interpreting the zoning bylaw. This is what you do all the time, and let me give you a couple of examples. For example, I know every person on this board is familiar with the case Powers v. Building Inspector of Barnstable. That's the case from the Massachusetts Supreme Court that the board has to rely on to determine whether an expansion or alteration of a non-conforming structure or use requires a special permit. You all know the test by heart. It's 3 parts: whether the proposed use reflects the nature and purpose of the original use, whether there will be a difference in the quality and character of the use, and the effect of the changed use on the neighborhood. Now, Powers doesn't have any applicability here, but I bring it up as an example of Massachusetts court cases that are always applied by this board. We see the same thing with variances. I won't go into any details about the 3-pronged variance test because you hear that all the time. You all know it. But every time you decide a variance case, you do so knowing that the Massachusetts courts have established that it is very difficult to qualify for a variance. So what we're asking you to do here is the same thing. Take the principles from DeBurro, DiGiovanni, and Bourne and apply them here. And you should also take into account the Massachusetts Supreme Court decision on what constitutes an accessory use. This isn't in our materials, so I'll drill down a little bit on this. The case is Henry v. Dunstable, and the citation is 418 Mass 841. It's a 1994 case. in Henry v. Dunstable, it's the lead Mass Supreme Court case that talks about what incidental means, and it really goes into some detail. And what it says is that the word incidental in zoning bylaws or ordinances incorporates two key concepts. It means that the use must not be the primary use of the property, but rather one which is subordinate and minor in significance. It must also incorporate the concept of reasonable relationship with the primary use. It is not enough that the use be subordinate. It must also be attendant or concomitant. So here, I mean, in your materials, there's information, there's the definition of the Nantucket definition of accessory use. There's also the definition from Bourne, and they're a little different. But what's important, and I think this applies in virtually every zoning bylaw, is that an accessory use is incidental, minor. That's what the Henry case teaches us. And it gives us the guidance that that accessory use has got to be subservient and subordinate to the primary use. Here, the weddings, the events, the goings on at Whales Watch, we submit are by no means minor or incidental, and therefore cannot be an accessory use. And we urge you to overturn the building inspector's decision. Thank you.
Sorry, I didn't realize I was.
Yeah, we're done unless Danielle has anything else.
Okay, I was going to move on to Attorney Kyberg to see if he has anything to.
I do have a few comments, and then I'd like to hand it over to Paul Murphy if he wants to talk. But first, okay. I'll make a few quick points if it pleases the board, Madam Chairman.
Sure, thank you.
What the materials that we received and the information that was rehashed again, the same materials we received more or less before the last hearing. It's an attempt for the appellants to try and show persuasively that these other cases and other matters are exactly the same as Whales Watch, which they're not. Westmore was different. The Stevens-Bourne case was different. We discussed those and we distinguished them last time as being different in nature and having a different factual pattern. But this is what lawyers do. So you received sort of a half-baked legal brief from the appellants also. It's something that I don't expect the board to try to read as non-lawyers and understand the nuances, nor is it complete. That's something that would happen later on if necessary in an actual court. The bottom line in this case is that there's been no zoning violations at Whales Watch. There's been no citations issued for noise violations. There's not even been any ticketing of cars to the extent that we know. There's no zoning law violations there. Jack Dunn, in the conclusive paragraph in his letter 20 years ago, found the same thing as Paul Murphy found, that there are no zoning law violations here. The appellants actually were on the right track in 2017 when they tried to submit a citizens warrant article to town meeting to change our zoning bylaw so that activities, certainly not unique to my client, that happen ubiquitously across Nantucket, so that some of those would become illegal or against the bylaws. They tried to go through the planning board to the town and have the townspeople change the bylaw. That's the correct civics way of doing things. If you don't like a law, you try to have it changed. So they failed at that attempt. They tried again the next year in 2018, and you can actually see these two failed warrant articles on pages 117 and 118 of the packet. So they tried again. They went to the planning board. The planning board unanimously voted against endorsing the warrant article. They were trying to change the zoning bylaw again, and that was never even presented to the town. Point is, that was the right way to do it, because what my client does is no different than what many, many people do across the island in renting their houses and having family gatherings using the zoning bylaw to put up tents when it's legal. That is legal and comports well with the bylaw, and is why Commissioner Murphy found no violation. And the appellants here tried to do the right thing in changing the bylaw that they didn't like. The problem is that the town didn't want to go along with it. And so they can try that again. But what they're trying to do now is to end run around the democratic process, and they're trying to have you sitting on the Zoning Board of Appeals to change the bylaw, or to change the interpretation so drastically that you've taken away what the townspeople have said in town meeting. The bylaw has been changed since the last 20 years, as you know, a couple times as it relates to tents and activities like my client and many other people do. It has been changed a couple of different times, and my client is still well within the bylaw. In fact, we would claim that he's under the bylaw due to a deed restriction that was put on his property. He's only allowed 4 tents, everybody else is allowed 6 or 3 per property. Point is, he's not in violation of the bylaw as it stands now, as it is written now. And again, the appellants tried to change the bylaw, but that didn't work. And so now, since they failed at that twice, they're trying to go around the democratic process, around town meeting, and to try to get you to change it as you sit on the board. It was brought up, claimed by the appellants, that Jack Dunn's letter said because Elliott doesn't advertise and it's not unrelated parties, it's an acceptable activity. Everybody who rents their house advertises, and everybody who has renters in their house is usually unrelated parties that they don't know that come and rent their house. That's what people do on Nantucket. Nantucket is not born, and it's not other places. What we do here is different. Many, many people rent their houses. They share the beautiful wealth of this island with people who come to enjoy it, and they rent houses to unrelated parties. The suggestion that my client rents by the night a 40-room hotel is absolutely, it's just fictitious. It doesn't happen. There's 15 bedrooms there. There's 15 bedrooms there 20 years ago. It has not increased an inch in size or changed an iota. It's been 15 bedrooms, and he rents only to people who are all together, rent the entire structure. He doesn't rent rooms, is what I'm trying to say. That's just simply not true. And there's never 6 events in 1 week. There are no events. There are family gatherings. He is within what is allowed by the bylaw, specifically relating to tents and the such. Thank you, Madam Chairman.
Okay. Is there anyone else who, let me just go to the participants list, who was looking?
Paul Murphy, we were going to give it to Paul Murphy after Peter.
Thank you. I just want to check in. I see hands raised for Drew Guff and for Mr. Gregory. Are those, and John Flannery, are those still up? And then Mr. Reed. Okay. So let's go to Paul Murphy first. And then we will go to the Mr. Reed and the abutters.
Thanks, Madam Chair. I just want to go through a couple of points in Danielle De Benedictus's letter that I disagree with, and I just want to point that out to the board. You need not really follow along with me with the letter. I'm just going to raise these points. I know you all have a copy of it. Just moving through the letter, I just wanted to these points. It says on the first page, at the outset, we would like to make clear that from both a legal and common sense perspective, nothing that 2 private parties agreed to 20 years ago prevents this current board from deciding whether or not Whales Watch is currently conducting a commercial venture. We agree. The board's not bound by that at all. On the second page, any agreements between private parties are not binding on the board. We agree. Down page 2, down at the bottom, it says the appeals court further ruled in Bourne in interpreting a bylaw nearly identical to Nantucket's that the commercial activity of a wedding event site in a residential zone is not an allowable use and cannot be considered to be an accessory to residential use. The notion that the that the Bourne bylaw is nearly identical to Nantucket's is just not true. They're completely different definitions of what an accessory use is. And that's very important. And I want to, if we're gonna base a lot of this off of the Bourne bylaw, then I want to read to you what accessory uses in the Bourne bylaw. It's important. It won't take long, very quick. Accessory uses, home occupations are permitted within a dwelling, but not its accessory buildings. There's no more than 30% of the gross floor area of the residence is used for the occupation. Not more than one person, not a member of the household, is employed on the premises in the occupation. There is no exterior display or visible storage or other variation from the residential character of the premises. The traffic generated does not exceed that normally expected in a residential neighborhood, and all parking required to service the occupation is provided for off-street other than within a front yard. So that is entirely different than the bylaw for the town of Nantucket, which defines accessory uses as follows. Simply this: separate structures, buildings, or uses which are subordinate and customary incidental to a principal structure, building, or use on the same lot. So the notion that the Nantucket bylaw is identical, I'm not seeing it. That would be true. It says that the use of a wedding event site in a residential zone is not an allowable use and cannot be considered to be an accessory residential use. Totally true if you're basing the bylaw on what Bourne's bylaw says. So I've got some problems with that. The next page highlighted a letter from Deputy Chief Gibson affirming multiple complaints to police, just saying I have information that conflicts with that letter. Right below that, testimony of the head of Nantucket's licensing department that the commercial activity at Whales Watch is in violation of existing liquor license laws. That's not relevant. Just below that, such activity has not only been already determined by our highest appellate court to be commercial, again, based on the Bourne bylaw, not allowed in a residential zone, but also is contrary to the purpose and wording of Nantucket's zoning bylaw. That's not true. Our bylaw specifically excludes residential uses in the definition of commercial. So I can't sign on to that point either. Page 4 goes on to say, Commissioner Murphy testified that a key distinguishing factor in which Westmore Farms differed from Whale Watch was that Westmore Farms was not a residence and the owner did not live there. Well, Westmore Farm, if you've ever made a site visit there, has two structures that are constructed to be event spaces with stages, professional stages, lighting, sound systems, open areas, open truss, roof situations. It's in every sense a commercial venue and constructed as such. The whole layout of the site is actually commercial. Importantly, the property is not advertised as a wedding venue. If you go on Wedding Wire, there's lots of information about Westmore Farm being advertised as a wedding venue. Next page, again, I touched on this earlier. You have in possession a letter from the Nantucket Police Department from Deputy Chief Gibson, in which he notes over the past several years, officers have responded to at least 14 large parties. How many years? 20 years? 14 complaints? I'm not sure that's excessive. The record before you mandates the conclusion that there is no distinction between Westmore Farms, which the building commissioner shut down, and the Whales Watch operation. I think there's definitely a distinction. You have two structures dedicated to event space. Nothing like that exists at Reed's Way. There's simply residential structures. It's rented for less than 9 weeks a year. And that sort of use is customary on Nantucket. It may not be in Bourne, but it is on Nantucket.
And I based my decision based on the wording of the bylaw. I realized that both parties have positions on this and they both have merit, but I had a decision to make. And I think Westmore Farm and Reed's Way differ. And for the reasons that I've actually laid out, the primary use of Reed's Way is a residential use. The accessory use is the weddings that are held there. And I think I've made the right call. It wasn't an easy one, but I'll respect whatever decision the board reaches in this matter. Thanks.
Thank you, Paul.
Thanks.
Let's see. So
You have a bunch of hands up there.
Yeah, no, I think we'll stick with, let's go to Mr. Reed first. And then I think we have, then I'll go back to Dan and Danielle, and then we'll hear the owners. Does that make sense to everyone?
There's also two neighbors that want to speak, Wendy Schmidt and Gretchen Cooney.
Yep, I'm going to get to them last because they're not appellants on this. So when I get to the members of the public. So again, Mr. Reed, you can finish out your presentation, and we'll circle back to Dan and Danielle. Okay.
Sure. I'll be as brief as possible this time. Was the board able to read my letter and the attachments that I submitted?
Was that the one that had the schedule of the whale watch calendar?
Yes.
Yeah.
Yes. Had the review by Christine and Justine and Chris. You know, I have a long history with Nantucket. This is my Nantucket residence. I use it year round. I'm at the property right now. I'm here a week or two a month year round. When I'm not here, I do like to rent it sometimes. And I think one of the board members asked last meeting, what's happening the rest of the year? How exactly is the property used? So I'm an open book. I went through all my calendars. I typed it out. I put the family name. I think it's very consistent to what I said in the last meeting, in that it's families with children using the property residentially. I'm here a week or two a month year round. I love the holidays, Thanksgiving, Christmas, July 4th, Memorial Day. That's when my family can get together and come here and use the property. There are 15 bedrooms. There's not 40 rooms, which is, I think, in the preamble to this application. That's just inaccurate. There's 15 bedrooms when I bought it. There's 15 bedrooms now. I haven't changed it. And over time, my personal use will grow and grow and grow, I'm sure, as I get older and I can work less and that sort of thing. But my job requires me to travel off the island, so I have to do that. The counsel for the appellants make this argument about intensity and frequency. And I see it over and over. And I'm not a lawyer, but I just like to point out my calendars. We can start with 2019. I've never done a wedding in July or August. I've never approved a tent for any reason in July or August. September, you'll see in 2019, there were 2 tent permits, both for week-long stays, or 1 7 nights, 1 6 nights. And then the average stay was 9 nights. I know there's a movement on the island to not have short-term stays. I don't do short-term stays. I don't do a night. I don't rent a bedroom. I don't do that. You know, these families use the property just as my family does. You know, July 4th, I'm the youngest of 5. My siblings come, my 13 nieces and nephews, and these families use it just as I would use it. I'll say, if my advertising, which my fiance did, is too exuberant, I'm glad to change it. If the board wants me to tweak the advertising, I'm happy to do that. You know, I don't offer commercial services. That's a key distinction that I see in these briefs. I don't offer any commercial services. If a family comes and rents the property and wants to have a private chef come, or wants to hire a vendor to set up a bar under a tent, then that's for themselves to do, just like anyone else using a home around Nantucket can do. I do not do that. There's 3 single family homes, 6 bedrooms, 5 bedrooms, 4 bedrooms. It's simply a residential lease. What else here? The final point, and this is very disappointing to me, but I think it's transparent to what's happening here. My lawyer, Peter Kyberg, noted my neighbor, Mr. Guff, tried for 2 years to pass citizens articles changing this zoning code in 2018 and 2019. It failed. Last year, it was a 5-0 defeat. Over 30 local businesses wrote letters saying backyard weddings are very important to the economy. After those 2 failures, suddenly the 60, 70-page document arrives on Commissioner Murphy's desk. And I applaud my neighbors for trying to get a citizens articles passed, because that's the right way to do things. If you don't like the zoning code, go to town meeting, change it, and I'm glad to comply with it. But I talked to Peter, I talked to Linda Williams, I talked to Arthur Reed. I say, here's how I'm using the property. Are there any violations? They all say, absolutely not. That's a residential use. Someone's renting it for 7 nights. They want to put a tent up. That's an accessory use. I consult with the best. I'm not a lawyer, but I want that to be clear to the board. And that there was some sort of liquor discussion last time. I don't provide those services. But again, if a couple or a family rents the property and they want to have the Island Kitchen food truck come by, my neighbors took a picture of that. I mean, that was a family. You'll see, if we can go to the 2020 calendar, Mr. Ricketts, that exhibit B is the 2020 calendar. So 2020 is very similar to 2019. I'm using the property for a week or 2 a month. I'm renting it to all families, some of them for 21 nights, some of them for 14 nights. And then in the shoulder season, sometimes you have a wedding of that effect. And so in this particular calendar, you can see it's an 8-night average stay. So it's exactly as I described the last meeting. I've never rented to a bachelor party. I've never rented to a bachelor party. I've never rented Fagawi. And if you walked up and down my street on Fagawi weekend or through Tom Nevers, you'd hear loud parties everywhere. My neighbor has a pool. There's pool parties by their renters sometimes. That's the nature of Nantucket. Half of my neighbors all rent their houses. Sometimes it gets noisy. I mean, I don't try to pass like a citizens article to ban houses that have pools from renting their house because there might be a pool party. But it's a total fabrication on the intensity and the usage. My calendars are very clear. Just look at this year's calendar. It's all families. There are absolutely no events, whatever that means, besides these families having breakfast, lunch, and dinner together during July and August. And then in September, I do have up to 4 tents. In here, you'll see there was only 1 tent in 2020. There were 2 tents in 2019, which was the crux of their 2 citizens articles to reduce the number of tents. And we said kind of the last meeting that my deed restrictions are already more restrictive than the current Nantucket zoning code, which is 3 tents per lot, 10 p.m. noise cutoff. I basically have 2 tents per lot. So it's already more restrictive. I'm actually beneath even my covenant. And the final point is it's become borderline harassment. I mean, my neighbors are calling I was roasting marshmallows on the beach with my godsons, and they're calling the police to show up and walk down my stairs to the beach and harass me, roasting a marshmallow. I mean, these are the same neighbors who never called me in 2016, never emailed me in 2017, never called me in 2018, never agreed to even meet with me until the building commissioner denied their request. Mr. Guff agreed to have lunch with me after Commissioner Murphy rejected his request. That is the first time they even agreed to have a meal with me. And I've repeatedly reached out dozens of times asking to meet with them. So if you're not willing to even talk to your neighbor and try to find common ground, I think it's clear to see that's because this is not true. These are fabrications. And if there's clear evidence, they can go back to land court with their evidence and show proof that I violated my deed restriction, but they haven't done that. Why haven't they done that? Because there is no proof. There is no evidence. I have not violated anything. So that being said, I'm glad to talk to anyone. I'm glad to have a neighborly dialogue. I'm free anytime for coffee or beer to discuss this and try to find common ground. And I'm disappointed that they've never done that with me. I'll leave it at that.
Okay, thank you, Mr. Reed. I would like to I'll go back to, I'll do the people who have their hands up, and then I'd like to have some board discussion. Dan Bailey, we'll go to you first.
Thank you, Madam Chair. I just want to touch briefly on one item that Mr. Murphy mentioned and one item that Mr. Reed mentioned. Mr. Murphy talked about the difference in the definition of accessory uses. I'd like to talk about how they're similar. And the Nantucket definition of accessory uses is separate structures, buildings, or uses which are subordinate and customarily incidental to a principal structure, building, or use. The Bourne bylaw, accessory use, a use customarily incidental to. That's why I talked about the Henry case earlier. That's the case that has defined what customarily incidental mean. Yes, Bourne goes further, provides actually a lot more guidance to the building inspector and to the zoning board about what is prohibited. You know, they've got caps on interior space, caps on exterior space. Nantucket leaves it much more open to interpretation and flexibility, and that's his job and your job to interpret it. But I would argue that the subordinate and customarily incidental language is where you should focus, and that the analysis, when you have to take that into account and consider whether this is a minor use, pushes it well out of the accessory use category. With respect to Mr. Reed's comments, Mr. Guff will speak to most of this in a minute. But Mr. Reed's comments are basically, well, what has changed? What changed is the Westmore decision. That changed things, and in our view, was the basis for the neighbors bringing this action. Prior to that decision, we didn't have any guidance from the building inspector on this issue. But when that came out, we felt very strongly that this, and Danielle has explained that this is very similar. And that's why, so there's no grand scheme here about, zoning amendments failing and then, coming at this from a zoning enforcement perspective. Our understanding of the application of the accessory use definition changed with the Westmore decision. And that's all I have.
Susan, you see the hands?
I do, sorry, I was on mute. So Danielle, do you have a comment? And then I was gonna go to the, then I have Flannery, Guff, Gregory, and I think I missed one, but I will get it.
Well, Dan's hand's still up, but I think he can take that down, perhaps.
Who?
Dan Bailey's hand is still up.
That's fine, yep. So I have Flannery, Gregory, and Guff.
And the other neighbors.
I'm gonna get to them at some point, but I'm not focusing on the neighbors right now. So Daniel, did you have any comments? Your hand was up.
In reaction to Mr. Kyberg saying that somehow we've lost this issue by filing a citizen's article, nothing could be farther from the truth. Part of the democratic process, in fact, at the core of the democratic process is the ability to appeal decisions. And that's what we're doing here. The building commissioner made a decision by Massachusetts law. It's appealable to you as a zoning board, and we have appealed it to you, and we intend to appeal it to either the land court or the Superior Court. It's up to us where we will go after this if we're dissatisfied with the decision. And then after that, after the land court or the Superior Court makes its decision, which I would like to emphasize would be on a de novo basis, which means evidence will be taken in under oath, which will be completely different than what takes place here. And then after that, that will be appealable to the appeals court and also subject to direct appellate review to the Supreme Judicial Court, which might in this instance take direct appellate review since it's an issue that affects more than just the litigants itself. So there is a process set forth by statute here, and we are adhering to that process. So certainly we're not doing anything that's undemocratic. The fact that their parallel paths are being pursued should certainly not detract from the fact that we are following the normal and generic process. And to add to what Attorney Bailey said about what's new, what also is new is the Bourne decision and the Di Giovanni decision. Those both came out after what happened 20 years ago, which was on a preliminary injunction, which has no binding precedent. As you know, that case was settled before it ever went to any kind of a decision, and a superior court or a land court decision are not binding. So here we have, if we get into the courts are going to look to what have the appellate courts told us? And we're just asking you, before it gets to that, to look at what the appellate courts have told you about this area. That's certainly going to be the standard in court, and it should be the standard before you. You now have a definition that the zoning board didn't have 20 years ago, a definition set by our highest appellate courts, the appeals court, and in the case of Bourne, and the Supreme Judicial Court in the case of Di Giovanni. And so I urge you to pay careful attention to those decisions.
Okay, thank you, Danielle.
That's all I have to say. Okay, thank you.
Madam Chair, sorry, can I just add one point of clarification quickly?
Sure, thank you.
So I think it's very important for the board to recognize that the Bourne decision, the Di Giovanni decision, those cases didn't set sort of a gold line rule of, how the board needs to rule if a certain threshold is exceeded. Those cases establish, relevant criteria for the board to apply, but it's for you as the Zoning Board of Nantucket to apply those criteria to what is normal and customary on the island of Nantucket, not in the town of Bourne or any other town in the Commonwealth. And to the extent that you do that and you apply your bylaw and apply these criteria to what you believe is normal and customary on the island of Nantucket, the appeals court, or land court first and then appeals court eventually, should grant deference to your decision, whatever that is.
Okay, thank you. Thank you for clarifying that for us. I'm going to go to Mr. John Flannery.
Great, thanks very much. I'll keep it brief. I know everybody's had a long day with this, but I just wanted to take 2 minutes to really reflect on the last meeting that we had and listening to the dialogue today, and really try to go back to some of the basics that we're dealing with here in, I think, in a community environment. This is really about a group of citizens trying to come to some sensible conclusion about how to handle this matter. There's a lot of legal arguments going back and forth, and I'm not a lawyer. I've had plenty of exposure to that in my professional career, but I don't pretend to be one. The arguments put forth by Danielle and Dan certainly make sense to me, but and I would say, despite Mr. Kyberg calling them half-baked and impugning the board's ability to understand legal arguments, I'd really rather not confine my remarks to the legal part of things, and rather go back to his exhortation around democracy and civics lessons, which I found inspiring. But the three basic points I'd make: the single biggest thing that I keep hearing in last hearing's discussion and today is very quick to conclude that this is sort of, in its essence, as a property, a random, infrequent sort of use of the property, might have wedding guests there by renters. And the tone of it is like, well, don't we all do this? Isn't this what everybody does with their houses in Nantucket? Isn't this just typical? Isn't it nice we can do this for our friends and our family? And my question to all of you is it? Do we all advertise our property on the internet as venues for 300 or 400 people? Do we advertise turnkey services, despite what Mr. Reed just said, that I can arrange for vendors, I can arrange for catering, I can arrange for flowers? Do we have our homes identified as a hotel on Google Maps? Do we hold multiple events, on multiple days multiple times a year. Do we have our houses known? Literally, I said this last time, this house is known notoriously in Nantucket as the wedding house. Ask policemen, ask firemen, ask cab drivers, ask Uber drivers, ask the power company, as I learned a few weeks ago. It's known as the wedding house. This is not what everyone does in Nantucket. And I think we're off base quickly conflating this with what the rest of Nantucket does. It's very, very different. The second thing I'd just say very briefly with this respect to the discussion that we had at the outset about Ed Toole, again, and the recusal. I don't know Ed Toole. I wouldn't know him if I bumped into him on the street either. But to me, that is an extremely circular discussion that on the one hand, there's no big deal here and no one should care and there's nothing to dispute. And on the other hand, somebody that's in the neighborhood and has had a problem with this is somehow conflicted. To me, that's a circular argument kind of going down a drain. The last point I would just finish with is really an appeal to the zoning board, which is when does again, this gets back to the civics lesson that we were urged to think about before, is when does the weight of a group of residents, a extended group of residents, having a certain reaction and point of view and experience counterbalance one resident having a different point of view? And when does the common sense test and community sense kick in here? This is a property that's been irritating people in this residential neighborhood for decades. And at what point do you stand back and say, are the neighbors the issue or is the property the issue? And I think the fact that we've tried different avenues and methods for relief is really a cry for relief. That's really what is happening here. It's not legal pursuits of this or that. I don't know Mr. Reed. I didn't know it was my obligation to reach out to dialogue with him. I have lived in the neighborhood much longer than he has. But the reality is the dialogue he wants to have is, let's talk about how many times I can have weddings or how we can reach an agreement here. And the neighborhood does not want a commercial property operating in the neighborhood, period, paragraph. There is no dialogue to have. So I would just finish, by saying we are all in this as a mutual civilian bond. We're all trying to abide by the zoning laws, and we're all expecting and counting on the zoning board to uphold the zoning laws. And so I just finish with that is all the legal discussions aside, this is a long-standing plea by many, many, many people surrounding one property for relief from the zoning board. And I urge you to think about that as much as the legal arguments. So thank you.
Okay, thank you, Mr. Flannery. Mr. Guff?
Can you hear me?
Yep.
Okay, thank you, Madam Chair. You've heard all the many legal arguments and criteria as to why the board should overturn the building commissioner's decision. And so I'll leave the legal parts to the lawyers and all of you who can absorb it better than I can. And you also heard why Westmore and Wales Watch are nearly identical. From what Mr. Murphy had to say, I still didn't hear that there was great differences. And also between last meeting, this meeting, a lot of information was given that I would say either misrepresented facts or half-truths, etc. And he can only deal with what he's given. A lot of those facts he was given were rebutted, refuted, shown to be different. And he's not a court of law, so he can only deal with the information he's given. So he was given a large dose of that misinformation. Mr. Kyberg has asked, and you might ask as a board, why should I overturn the building commissioner's decision? This has been going on for 20 years. Nothing has changed. But the fact is a lot has changed. Jack Dunn and the ZBA approved the activity that it was 4 weddings only for friends and family. That has changed. He also approved the activity because it was never advertised. You've seen a heavy, heavy advertisement of Wales Watch in all the journals and also all the online wedding advertising sites. That has changed. Mr. Kyberg mentioned the property hasn't changed an iota. That's not true. There's a swimming pool and another outbuilding and hot tubs. It's larger in that sense. And Mr. Reed tried to expand the property by buying the Hoey's property, the neighbor property next door, the Gregory property next door. Why? To expand the commercial operation, make it bigger. And now, as opposed to 4 weddings, it's now 4 weeks. And during that week, lots of events are held that are extremely loud. And it's not just tents, because without a tent, especially during COVID, the noise travels across the entire Tom Nevers area. So my example of 6 events in 8 days in 1 week in September, that has changed. That's different than when it was under Elliott's. And then most importantly, the law has changed. In those 20 years, there have been more cases that have been decided that would place the activities at Whales Watch firmly in the commercial camp. And so it's convenient to say that nothing has changed, but that's not true. And we're asking you to make that important determination. Thank you, Mr. Weisheit, for what you mentioned about Superior Court and Land Court. And you can definitely advise the ZBA as to how it might work out in court. We feel quite strongly how it would, but the real question that they'll probably ask is what you mentioned. What is customary on Nantucket? And here is where it's not black and white. And this is why we're pleading for you on the ZBA to make a distinction. Is it customary and incidental to have weddings at residences in Nantucket? The answer is yes, definitely yes. But is it customary to do active, full-on advertising to attract customers, charge tens of thousands of dollars to non-family, non-relative groups, aggregate and transform 3 houses into a major event facility for a week at a time, during which time you can have many loud and disruptive events for up to 400 people for the final big to-do? And that, I believe the answer to that is no. That is not customary, and it's not incidental. It's a major business. And so it crosses a line. And at some point, gatherings that large and those events that large cross a line. And what we're asking you as the ZBA is to make that one very important distinction. If I make a pizza for my family and friends and serve it at dinner, that's customary and incidental. If I make hundreds of pizzas in my home and I deliver it all around Nantucket, that's a commercial business in a residential zone. So we're asking you to make that distinction about crossing a line. Also, Mr. Reed said that he lives there, and that's should be a determining factor. Well, Mr. Murphy mentioned that in his letter. But the question of residence, it's a factor, but it's not the determining factor, because by the logic of just being resident there, I do reside in my home in Nantucket, but can I run that pizza business? Can I open a bar? Can I have dog kennels? I have a dog, but I can have a dog kennel. I go to the doctor because can I have doctor clinics? So it's the size, the scope, and making a determination. And that again is the role of the ZBA, and we're asking you to do that. If Mr. Reed has family events for his brothers and sisters, or if he himself wants to get married there, we would be delighted to celebrate with him. We are not against renting Whales Watch to people who live there and reside there as he would live there and reside there. What we're only opposed to is the large, loud, disruptive, unlicensed, and sometimes unsafe nature of holding very large weddings and events. So I also think that not overturning the building commissioner will make it difficult for everyone on the island. And that is because if you uphold the decision, the next steps would be for asking a court to decide. And if they do decide along the lines of what we think the precedent law will show, in fact patterns that are nearly identical to Whales Watch, then the zoning board's hands will be tied on cases where there's even a hint of commercial activity. And case law will be set specifically for Nantucket, not just Bourne. I know it's not convenient for you to overturn the building commissioner, but I think you've been shown that he's been provided with a lot of misleading, conflicting, or inaccurate information. And it's the role of the ZBA to make those tough decisions. And so you're our only protection against, as John Flannery said, against wrong calls, bad calls, or decades of people who are aggrieved in the neighborhood. So for all those reasons, I and the neighbors all around the area respectfully request you to overturn the decision of the building commissioner. That activity at Whales Watch is somehow not commercial activity. I think we've shown that Whales Watch is truly outside the norm, and that their business of renting out the property through mass media advertising to third parties for large sums of money for weeks at a time is not in any way incidental to a single family's use. And I know that takes some gumption and courage to overrule the commissioner, but I think in this case it's warranted. And I thank you for listening to all of us who are aggrieved, whether it's recently or in the decades before, on this case. Thank you.
All right, thank you, Mr. Guff. Next, we'll move to Mr. Gregory. And I just want to point out we have other things on the agenda here. There's more people who want to speak. We haven't had board discussion yet. So unless really you have something new to add, we don't need to regurgitate the same. I know your position, and we don't need to hear the same facts over and over again or the same position. So just try to keep it brief to something new, something you're responding to specifically, and let's.
Well, I'm simply asking that you all personalize it to the degree you're able to. Imagine yourself in our shoes, and to back up what John Flannery and Drew Guff just said, why would we all be here? Why would we raise this? I also wanted to briefly note Commissioner Murphy stating that the cops had come to the Reedway residence, I believe he said 13 times in 20 years. Now, I don't know about the rest of you, but the cops haven't come to my house ever. And there must be a reason they're showing up, just like the reason we're all showing up here today. I did purchase the land from Mr. Toole. I was unaware of his role in the town. I wanted to repeat that because Mr. Reed was trying to suggest that there was something untoward about it. And I want to be sure that my reputation is not impugned by that. And I also would add that I had to build a fence there because people who were staying at Mr. Reed's place, including all of the vendors and all the contractors and all of the guests, were parking on that property. I would ask all of you, if we're not going to vote today, which may be a possibility since Mr. Toole's recusal or assumed or possible recusal might delay the vote, please drive by, see the width of the street, see my driveway across the street, what proximity it is, and imagine yourselves in our position. We're not simply making this up because we just decided one day that we wanted to get Mr. Reed. I wish him well with his own wedding. I'm glad to hear his nieces and nephews go there. I have 25 nieces and nephews. I'm the third of 8 children. I love having my family there. Oftentimes when he's having an event, we can't hear each other in conversation in my own home with the windows closed because of the noise and activity and other things going on across the street. Thank you very much for your attention today. This has been very long. I much appreciate your efforts. I know it's all volunteer. Thanks very much.
Okay. So we have, I have 2 more people who were hoping to speak. The first one is Mr. Randy Ringer, who's an owner of 3 Chuck Hollow Road, who's not a party to this, but who is listed as interested. Do you still wish to speak, Mr. Ringer?
Yes, I do.
Okay, like I said, please try to keep it brief and keep it to something new or a specific response so we can get to board discussion.
I will. I'm Randy Ringer. I'm the president of the Tom Nevers Civic Association. We represent the 535 property owners in Tom Nevers. An overwhelming majority of Tom Nevers residents do not feel that a party house, such as Whales Watch, has any business being located in a residential neighborhood. Let's be clear, this is not a backyard wedding venue. This is a party house, and that is not what we want in our neighborhood. echoing what John Flannery said, when do the residents' desires matter? Has any neighbor come forward to support Whales Watch? Has anybody in Tom Nevers come forward to support Whales Watch? And I very much doubt it. And what Mr. Guff just said, I thought it was a bit disingenuous for Mr. Reed to call police work harassment, and Mr. Murphy to cite that the fact of a lack of police citations means that there must be no problems. So I go on and speaking for the 535 property owners in Tom Nevers, a party house has no business in a residential neighborhood. Thanks.
Thank you, Mr. Ringer. And I have one more attendee who has their hand up, Wendy Conway Schmidt, who also is not a party to this, but who is interested in the application. Do you still wish to speak? No. Okay. So
you may need to unmute her.
She has to unmute herself, I think.
I just did it. Sorry. I had to do that.
Yeah, thank you. Can you guys hear me now?
Sorry about that, Wendy.
Hi, thank you. So I'm Wendy Conway Schmidt. I just want to make sure you guys know that I'm not the real Wendy Schmidt on Nantucket, but I happen to have the same name. And I just want to echo what my neighbors have said, but also just add in, a couple of facts. So I live about a mile or so down the road. I'm on Bosworth Road, and we can hear the partying and noise loud and clear all the way down by us. And my neighbors and I often discuss, on these party weekends, just the level of noise that, comes so far down the road to us. But the one thing that I do want to say is that I also rent my home. I have a high value property that rents for over $30,000 a week. And I frequently get asked whether we would allow weddings to be hosted at our property. And I would never, ever rent our house for a wedding for all of the reasons that have been stated by my neighbors, by, Mr. Guff, Mr. Flannery, what Mr. Ringer said. It's just inconsiderate to my neighbors to do that to them. And I think we can make plenty of money as homeowners and people who rent their properties, and these high-end properties in particular, without disturbing our neighbors and without the noise pollution that's caused by these party type houses such as Whales Watch. So I just wanted to add that, Mr. Reed, while I'm sympathetic to your plight here, I think you can still make a lot of money renting your home without these parties. And I was fully booked this summer. I'm already fully booked next summer. These high-end properties, there's such a huge market for them that we can make money without disturbing our neighbors. And that's just the point I wanted to make.
Okay, thank you. And I just saw there's a new hand up there from Gretchen Cooney, who's 65 Winoma Way, who's also just interested in this application. I think she's unmuted and can speak. So
yes. So a lot of what I wanted to say has already been covered by Mr. Guff, Mr. Flannery, and Mr. Gregory. I did want to add a couple of additional points. Mr. Reed spoke with great pride in the prior hearing about how he rents almost exclusively to families and for a minimum of a week in duration. And what has already been stated in different ways, I see that as being part of where the problem lies. If it were simply 9-10 days or 2.4% of the calendar year or an occasional Saturday night, that would be one thing. But the part of the problem is that when you get up to 40 people staying on one property for a week or more, the size and the scope and the intensity and the duration of their activities, whether you want to call them events, activities, weddings, they become very disruptive to an otherwise quiet neighborhood. And it's very disrespectful of the residents. Another point I wanted to make is that Mr. Reed stated today and at the last hearing, I don't allow weddings there for July and August. I was at my property until the Sunday of Labor Day, which was September 6th. And on August 26th, there was a wedding on his property. It was not a large wedding. There was no tent. The gathering, I can't remember whether the maximum gathering limit was 25 people or 50 people at that point because of COVID restrictions. I can't tell you whether or not he violated that restriction. But there was a Nantucket party rental truck earlier in the day that dropped off tables and chairs. And they set up a lighted defined area that was, large tree branches and hanging lights. And there were photographers, and there was a woman in a long white dress. So the fact that he said that there were no weddings there in July and August, either that's not entirely true, or he wasn't aware that there was a wedding taking place on his property on August 26th. And I would just like to finish by asking the board to really ponder why a 43-year-old single man with no children, and I recognize that he's engaged, why he would have an interest in buying 3 homes and with the intent of purchasing 2 more adjacent homes, as well as 2 undeveloped pieces of property across the street, if not for trying to create a standalone, self-contained commercial establishment that meets the needs and the wants of Nantucket vacationers. Thank you for giving me some time.
Okay. Sorry about that. So I think that is all of our hands that have been raised.
Can I briefly respond just because I was mentioned a few times?
Yeah, sorry, who is that? Is that Mr. Reed?
Yeah, I'll be very, very brief.
Okay, I'll give you a minute to respond.
Okay, just again, I hear a lot of vague things about noise. I've never received a noise violation in the mail. I've never received a parking violation in the mail. I've never received a Board of Health violation, none, 0 during my ownership. My calendars are 100% accurate. They show that I even use the tent permits less than I'm allowed. And the families that come in July and August, again, if people are renting different houses, who is going to have an event while someone else is using another house? It just doesn't happen. These are quiet families with children. Ironically, one of Mr. Guff's friends from Connecticut rented the Whales Watch 2 for a week this summer and had a wonderful time. She wrote me a beautiful thank you note. She didn't know Drew lived next door at the time. So again, clearly, it's become a level of harassment. There were 2 failed citizens articles. If they want to pass a citizens article that 15-bedroom properties can't rent their house, or they can't have any tents, then write the citizens article, get it passed at town meeting. Coming up with dossiers full of exaggerations and mistruths isn't productive, especially when you won't even take the time to have lunch with me or coffee with me. I think it's pretty clear that the timeline here of 2 failed citizens articles followed by a 60-page submission to the building commissioner, I think is pretty transparent that it was failure to change the building code. So why not just, protest, call the police when he's roasting marshmallows with his godsons and try to harass me, which capped off with, and I forgot to say this, a fraudulent request for a wedding by someone named Latuski that Attorney Benedictus put up on the screen the last meeting. For weeks, some woman called me from Florida recently in September and said she injured her shoulder. It's her dream to have a Nantucket wedding, playing upon my compassion, and carried on this huge, false request for weeks, only to find out she's Danielle's friend. There's pictures all over Facebook. She was hanging out at the summer house then. This is the level of harassment I'm dealing with right now. It's not fair. And again, where are the violations? I'm operating within the zoning code. If they want to change the zoning code, be my guest, but I've yet to see on the screen clear violations, date and time. I have not heard it. I have not seen it.
Okay, so I'd like to move on to some board discussion now. We've been going at this, it's now 3:05. So
don't forget, we have to be off by 4:30 at the latest.
I know.
I want the others to know that. I know you know, but I just.
So I feel like everybody's had a lot of opportunity to say what they need to say. And of course, we can go back to you as we discuss and as we need to, but I'd like to start out, I think, let's see, I agree with Paul Murphy and town council about talking about Bourne as that is a distinguishing, that's a different bylaw. When it was read into, I think by Mr. Bailey, he didn't continue on and say, you know, right, it's a use customarily incidental to, but it also says in Bourne, it has to be on the same lot as a principal use and occupying less than 30% of the habitable floor area on the premises and less than 50% of the lot area. So that is much more restrictive than Nantucket is. So I think we can distinguish those. And even the definition of customarily incidental, I think if we parse that out, we can also distinguish that. And the other thing I want to remind the board of is, you know, town council reminded us that we can look at these cases and apply these criteria, but to our own bylaw, and that yes, the definition for the test for the variance, the powers test, those are long-standing criteria that we hold on to, but I don't believe that we are bound to this case at this point. And I think that if we look at customary uses on Nantucket, you know, house rentals and weddings can be seen as a customary use. I also looked at we look at the materials that are provided to us by our applicant. And I looked at the 2019 and the 2020 whale watch calendar. And 2019, the home was rented only in 5 months of the year, there were rentals. In June, it was less than 10%. July, it was less than 25% of the time. August was 91%. September, less than 50%. October, less than 25%. And the rest of the months, it was not rented at all. For 2020, same thing, 1, 2, 3, 4, 5 months had rentals. June this year was less than 40%. July was up to 82%. August, 86%. September was about 70%, and October was less than 50%. So this isn't. I'm just making a summary, and then we can. And these are just my observations. When we talk about the letters to Dunn, as far as the prior decision on these properties, it does say that he advertised on page 49 of the packet, that he advertised, he had tents, he had portable toilets, etc. And the letter on page 57, Dunn found there was no commercial use. And on the letter on page,
you want me to share the packet?
I mean, we can, sure. But this goes to the point that when the appellant was saying, you know, that this is distinguished because there was no advertising, at least that's what I heard. The appellant at the time when Melissa Philbrook wrote the letter to Mr. Dunn, there was advertising, and they said that there were all these things. And then Mr. Dunn's letter back to Melissa on page 83, which the appellant relies on to say that Mr. Dunn found this because it was there that the Elliots denied that there was commercial use by each weekend by renters of the property, and that there were family and friends were the users of the property, and that his end result was that the use of the property had been no different than is allowed by the zoning statute. And so this is what the appellant's relying on, one of the things, and there was advertising, and our owner here today has said the same thing, that it's, you know, probably a more loose definition of friends and family than there was in 1988, pre-Facebook and all of these other social media connections that we all have. But you know, the Elliott said that there was no commercial use each weekend, and each weekend, right? This isn't rented each weekend, you know, of the year or even the entire season. So I find that to be, you know, more instructive than I think in a different way than the appellant argued. And then finally, just on my feeling on the Westmore Farms, I think that these are two different animals. I think that Westmore Farm, you have barns or buildings that have no residential use at all, that are standalone on their own lot, clearly built for entertainment. I've been to the property myself years ago, but you know, there's no, for those barns, there's no potential for even any residential use. And for those entertainment areas where there's the stage and the bar and all of that stuff. Whereas we're talking here, these are residential homes. And so that it distinguishes that, they seem distinguished in that way for me. But so that's just kind of my summary and my notes while we were going through this. And I think I will go down my list of board members to see if anybody else has any comments, questions, or thoughts on this. So Lisa, if you don't mind, I will start with you just because you are top on my screen and also top on my list here.
Although I agree with much that you had said, I feel that the scope of this is well beyond renting out a house to a family to come enjoy Nantucket. It's advertised as holding 39 to 40 people. The scope of it is just way too great for me to feel that it falls under an accessory use to a residential neighborhood. It is advertised, you know, he does say that he offers commercial. He does let us help. We've planned our own wedding at Whales Watch and helped with many other weddings and events here in the past few years. We know the ropes and many of the vendors personally. If you'd like us to be a resource to you beyond leasing, inquire about our VIP package. So it's clear that his scope goes beyond the rental of the property. And I think the use is too intensive for a residential neighborhood.
So Lisa, I just want to touch on that too. I hear you on the, like all together, but I also think that the nature of rentals has changed like over time, where
it doesn't mean that, right? Yeah, but
no,
doesn't
like people do like expect now that their ferry reservations are made for them, dinner reservations are made for them, like help me set up this, make my critter cruise reservation, like whatever. Like there's a, and I don't know where that
I think it changes when you have three buildings that are rented together that bring in a group of people that could be 40 people in a residential neighborhood. It's not a house on 3 acres with, 20 residents surrounded in an area that has a lot of space around, and are protected from noise and the porta potties. And, I agree, the food trucks can come in and make, I've been at parties where the food trucks, in front of a house in downtown. I mean, that happens, but these are clearly different types of events and, or activities, I should say, because they're right. There might not all be weddings, but I know that when I get together with my family, who can sometimes be 70 people, we're loud and we're obnoxious. We're not having an event. We're having a reunion. We all get together after dinner. We drink, we smoke cigars, we talk, and I just think it's just too intensive a use in a residential neighborhood.
But then how do we, so then he still owns 3 houses. He can still rent them out you can rent it to 3 separate groups, right? Like we can't.
I don't know. It's a tough situation. And, having said that, I feel bad, going against Paul Murphy's determination, but I do think that it is a problem and has been a problem in this neighborhood on Nantucket for years. So there's clearly something wrong. And, I think just brushing under the rug is something that is allowed in this neighborhood because it's always happened or because rentals happen all over the island is irresponsible. It is a different scope.
Okay. I'm going to move on. If you're done, Lisa, sorry.
Yeah, I'm finished. Thank you.
Okay. So Michael O'Mara, you're next on the list. Do you want to contribute to this discussion?
I agree with both Susan and Lisa, several points, and feel that Mr. Reed has taken the zoning bylaw to its maximum limits, and in some instances is probably going over the line. I heard him say earlier that he is willing to tone down his advertising campaign. And it appears that his big events are out of season, which was agreed to several years ago. So I don't find any compelling evidence to overturn the building inspector.
Okay. Karen, you're next on the list.
I don't have much to say. In the spirit of moving forward, I'll hold my comment, but a lot of what Lisa said is pretty much stuff that I agree with 100%.
Okay. Jeff?
I would agree with a lot of what Lisa said. I think Mr. Murphy is sort of stuck in a little bit of a spot here. I think he made his determination based on reading the bylaw and understanding the bylaw. Probably the bylaw, along with a lot of bylaws in the town of Nantucket, needs to be better thought out and possibly rewritten. But I feel, my personal feeling is that Mr. Reed has really stretched the limits of what is a residential neighborhood. And I really can't support the continued use of the property as it has been. That's how I feel.
Mr. Mark Poor? Mark, are you here? Do you have anything to add?
Sorry, I'll unmute myself. Thank you. I'm kind of troubled by what's happened in Nantucket over the 30 years that I've been out here, and the fact that our bylaws have not kept up with the amount and density of development here. So we put ourselves into this pickle where, to be fair to everyone, the way to, I think, approach this is by a town meeting. And I know that has not been successful, but we're looking at things that are going to only evolve further and greater from where they are right now due to the pressures on this island. Where I have my biggest difficulties with the scope of this particular project is that I cannot find where I consider this a normal and customary use of residential facilities. The advertising bothers me. Some of the newer amenities that apparently have been put in, and all I can do is look at an aerial photograph while I'm talking about this, lead me more to applications that speak towards a commercial enterprise. And while I don't want to make that my closing statement on this matter here, is I think the town's got some work to do to be able to help people out so they understand what they can and can't do here on the island. That said, this is a very dense project, and I can understand people's concerns in the neighborhood to see if they can mitigate some of this. And that's all I have to say.
Okay, and Jim Mondani.
I guess the way I look at this is I don't look at overriding zoning or Paul's decision lightly. And I think he made the correct decision under our existing bylaws, the way they're written. I think a lot of our comments relate to some policy decisions, which I know we've all gone around on this, but it, you know, something that probably needs to be taken up by the town. And if we determine, there's no doubt that this use is further down the spectrum than whatever 90% of the houses on the island, but I don't see that being in violation with our existing bylaws. You know, what is a minor accessory use? Is it 0 weddings? Is that what we're saying? No one has seemed to be able to give a number of what number of weddings would cross that line. It sounds like 4 is too many. Is too many? So I don't think it's for us to override a decision based on that. You know, if you're renting your house out for $30,000 a week, you know, and in Nantucket, it's probably not a big deal, but that's pretty commercial to me. As far as advertising goes, I don't think advertising makes a difference. If I rent my house out 1 week for $30,000 a week, and I advertise it on everything just for that 1 week, suddenly have I crossed the line because of advertising? So I guess my point is, I don't think this violates our bylaws. I understand the neighbors. This is definitely farther down that spectrum, but I don't think if I were to vote on this that I could override Paul Murphy's decision on it.
Okay, so I think we've got a good picture from our board. Do we want to have more discussion? Does someone want to make a motion on this? And I believe the motion would be to overturn the building commissioner's determination. And so an aye vote would overturn Mr. Murphy's determination, and a nay would support the determination that there is no commercial use at this time.
Madam Chair, can I just request to add a little verbiage to the beginning of the motion?
Sure.
Something to the effect of, for the reasons discussed during the board's deliberations.
Okay, so does someone want to make that motion?
I will make that motion.
Okay, so Michael's making the motion for the reasons discussed in this hearing, that to overturn the building commissioner's determination of no commercial use. Does someone want to, who would like to second that?
So as a point of clarification, an aye vote is to overturn.
Yep.
Good.
Right, because we always want to do it in the.
Yep, good.
Right,
Yeah,
okay.
yeah,
So an aye vote is to overturn. Lisa, do you want a second? Okay, so Lisa seconds. I'm going to do roll call. And so we are, so Lisa, well, I'll start with myself. So Susan McCarthy, nay. Botticelli. Lisa,
Aye.
okay, that's one aye. Michael O'Mara,
Nay.
Karen,
Aye.
and Jim Mondani.
Nay.
And that's 5, right? So I have two ayes and 3 nays. So that motion fails, right?
Yes.
Right. So we can move on to the next application.
So to be clear, Madam Chairman, the decision of the building commissioner is upheld.
Correct.
Yes.
Thank you very much.
Thank you, Madam Chairman.
Yes, thank you all for your time and your energy on this.
Madam Chair, can we take a 2-minute break?
Yes. Yep.
You need more suntan lotion, Mike?
Thank you, Madam Chair.
You're welcome. Thank you.
Thank you, Madam Chair. Appreciate it.
Thanks, Madam Chair.
Thank you.
Sorry, we'll take a 2-minute break and we'll be right back.
Timing you.
Susan, anyone who's incidentally staying on that doesn't need to stay on can leave. I see one person from the previous matter who may not have logged off properly. Just oh, she just did. She just did. Okay, that worked. All right.
Okay.
Eleanor?
Yes, Michael?
Just for the record, Mr. Mondani's name's spelled wrong on my screen.
Oh, I'll correct that. I didn't do that. Let me fix it though.
It was spelled wrong.
Notice. Let me fix that. Mondana. There. Thank you.
Nice catch, Mike.
Well done.
1, 2, 3, 4. Do we have 1, 2, 3, 4? I think, can we, I know we're waiting for a couple people, I think, but can we just, the next one is the request to continue actually, Can I do that one? Lisa chaired that one. Should she handle that?
Lisa should handle that, yeah. I mean, it is just a request to continue, but she should, since she was.
Yeah, can you do the rest request to continue, Lisa? We'll just get that done.
So that's the request to continue.
For the sales.
Yeah, I don't have the item number in front of me.
23.
Item 2320.
2320, till the December 10th hearing. Correct?
Yes.
Okay. Can I have a
And-
motion for that?
And in
make
fact,
that motion.
since you won't be here, that's, well, we'll cross that bridge when we get to it. We'll have to mull in somebody if they weren't here, I think. But I think other people were present, so we should be okay.
Okay. So
I'm
did
here.
you make
I'm
a,
here.
Michael?
Okay.
Yes.
Okay, anybody want to second that?
Second.
Okay, all those in favor? Oh, I have to do a roll call. Sorry. Michael?
Aye.
Karam?
Aye.
Jim?
Aye.
And who's my last person? Jeff? Can't see you all.
Aye.
Okay, and I'm aye.
Okay. So, Ed, are you back? Whoops, this isn't right.
Yeah, I'm here.
Okay.
Well, you sound excited.
Just got the worst headache.
Well, that was
say that.
interesting.
I need some water. So, oh, I know why. I'm looking at the wrong paper. So, all right, so we can start with Linda Yates 24-20, which is 21 Darrymore Road. Sitting is myself, Lisa, Michael, Karen. And that's only 4. And at the table, we have Jeff and Jim. How come we only have 4 on this one?
Jeff was on.
Ed was not there, was he?
Yeah, I wasn't there by then.
Yeah, he had to leave, I think.
But but Ed, you sat on this before, right?
Well, what is the particular case?
This is the one, it's Linda Yates where,
No, I didn't sit on Linda's.
No. At the last meeting, Ed wasn't there, nor was Mark Poor. It was Jeff, Jim, Kieran, Lisa, and you, Susan.
Mark was actually there. He had no audio, but you're right. We should probably, the way I have it on the staff report is.
well, we have 6 people, so.
Yeah.
So I think we're okay. Okay, so Mary Ann, do you want to?
Yep, I'm happy to start. Mary Ann Hanley for the applicant,
Mhm.
Linda Yates. At the last meeting, you had asked us to follow up on a couple of items. One was the status of construction. I'm happy to report that everything is basically done. The driveway apron was finished this week. The DPW and HDC can now sign off because those are completed. Jeff Morash met with the builder. Everything on the interior is done, and Jeff basically told him, get me the card and we can do the final inspection sign off when the building department opens. I guess it's closed for a couple of days. So then the second thing that we tried to do was to deal with the land court, to try and get them to move this up as an emergency, quote unquote. That didn't go very far, but we have talked. I've talked to the chief title examiner, as has Vicky. She has indicated to us that she has it on her desk. She is working on it, and she hopes to get it out to us. But she said, I can't promise you anything. She said, as you know, we're in the middle of evictions. Our court case has been backed up for months and months. She said there are things that are truly emergencies. And to be honest with you, the land court's never thought that Nantucket yard sales are emergencies.
It's still a really positive sign, though, because getting her to respond, which she's done twice in the last 3 weeks on this particular matter, is huge.
In your file from Vicky, who basically is echoing my sentiments, it will happen. And they've created a lot. The surveyors have looked at it. They're fine with it. So really the only thing that has to happen is for the S petition to be an order from the court issuing, say, yes, the town now owns the lot, and then the town can turn around and sell it to my client. So what we are asking for, again, is to eliminate that condition regarding no CO until the yard sale is done, because we cannot predict when it will be done. I mean, we could get an order in 2 weeks. We can get an order in the middle of April. I just don't know when it's going to happen. And it will not be treated as a priority by the court. They just have too much else going on. My client is willing to put money in escrow. I mean, if the fear is that she's not going to buy it, which is a condition of the decision that's not going to go away, you know, she has to buy it, and if she doesn't, she'll be non-conforming. I talked to Eleanor, and it's the sale price is about $8,800. We'd have to put some money in escrow to cover that. I doubt town council or the town would want to get involved in holding it. I'm happy to hold it, provide proof that we have it to the ZBA, just so that when we're ready to close, we can close. Linda, she needs a place to live, and she's about ready to, move. She'd love to move into this house. I don't, maybe one of the other things that we can do is, we could try and modify the condition that the yard sale is still pending by the middle of December. We could get the CO anyway. By the time you write a decision, by the time it goes through appeal process, we're going to be, in the middle of December anyway. But I don't know how else to fix this. The house is done. It's built. It's built in conformity, and my client wants to live in it.
Marion, maybe I'm missing something. Why can't she move in?
Because it doesn't have a CO. We can't get a CO until the yard sale happens. That was a condition of the variance.
But I mean, you and I both know we have real estate transactions all the time where people don't have a CO and they're living in the house.
Yes, I know, Susan, but that's basically not what the zoning bylaw says. You're supposed to have a CO. We want to do this correctly.
Mm-hmm.
So
we would hold. Well, I mean, holding.
I mean, it's 8,800. I would say we could put 12,000 in escrow, so the money's there. The money's there for the land bank. We usually have to pay town council's fee on the yard sales.
It's that if I may, Madam Chair, the 8,800 is an approximate minimum cost at the current valuation of the square footage through the assessor. But the Real Estate Assessment Committee is within their purview to up that cost based on certain considerations. I don't know that they would. Typically, those considerations are waterfront, water views. For instance, something that's right on Brant Point is valued at $24 a square foot, and something that's landlocked in Surfside is usually $2 a square foot. So I don't know that would occur with REACT, but just want to remind the board that's a minimum price.
And as I said, we're happy to put a bit more than the minimum in. I mean, if you want 15,000, Linda, here I am spending your money, but would you be willing to put 15,000 in escrow if the board wanted that? I think she needs to be unmuted.
Linda, are you? Yeah.
I apologize. Yes, I would be willing to do that. Would you be looking at what the other parcels sold for?
Yeah, Linda, there is the Real Estate Advisory Board. They would take that into consideration as well.
Okay. But yes, I'd be willing to do that.
Keep in mind, if assessed values have changed since those sold, that would also impact the value.
Understood.
But
well, it probably, I'm sorry to interrupt again, but I just checked in because I check in every 6 months when I have these pending issues, and the price factors literally just changed within the since Debbie retired, because they were very, very delayed in changing the price factors. So they just changed. So I don't think the 350 is going to change. What is unpredictable is what the Real Estate Assessment Committee will do in terms of tacking on an additional factor to that, which they may or may not do. I don't have any way of knowing that until we meet about it, but sometimes they do based on different factors and value. But it wouldn't necessarily, the assessor has set his price. That's unlikely to change in the next 6 months.
So does 15,000 sound like a reasonable number?
Yes, definitely.
I'm not going to do roll call on this, but does anybody have any feeling about this idea of holding funds in escrow, having Mary Ann hold them. I don't have any problem myself with Mary Ann's firm holding them even.
I think the town's protected and we should go forward.
If I may, I don't think it was the cost that was the issue or the town getting any money. It was the precedent that was the biggie for me, at least. I don't know if it worked with everybody else, but that's just my 2 cents on that.
Yeah.
So
hold on one second. Hold on one second, Jim. Hiram, I agree with you. For me too, it was this precedent. It was this idea, but I'm starting to come around that this is taking so long. Hearing from Vicky, and also just personally having clients with other matters in the land court. I think I'm coming around to, if we can somehow tie this to this unique situation of the sort of the yard sale in conjunction with COVID, in conjunction with the change of the chief title examiner at the land court. I mean, the slowdown has been, it's been crazy, and it's gone. I think now it's gone beyond what I was feeling last year when we were in person meeting, talking about, or when we made the decision. So I think yes, there still is that concern about precedent, but I think if we worded it correctly, I can be brought around to letting her move forward in some capacity. But again, I'm one person. So Jim, let's hear what you were going to say.
I said this last month. I agree with Karen. I have a concern about that, but I think this is an exception. I don't think we should or would be held to this precedent if we made the decision to allow this or remove the condition, especially if we're putting twice the estimated amount in escrow. If that's our concern, I know that's probably not our concern. But yeah, I still feel the same way, that this is an exception and it's unreasonable, and for Ms. Yates to go through this, and I'd be in favor of it.
May I say something, Madam Chair? In this instance, and I've been communicating, as I said, on other occasions with Ms. Yates and her attorney for years about this. They've been very patient, along with several other people who are in similar circumstances. But what's different for me in terms of the precedent is this was a vacant lot. She built upon it so she could live on it. The vast majority, off the cuff, the vast majority of the cases that are held up, the land court cases that are held up, that are yard sale parcels, are already built upon. So if people are coming up to us because they want to build a pool, or, oh, they want an addition or bump out, that's a different scenario. This is a house that she's built to live in on a vacant lot. So it seems a little different than in terms of the precedent to me. I just wanted to point that out.
So let's see what did I just do? Michael, did you have any comments on this one? Michael's muted. I'm sorry, what was that, Michael?
I'm happy with it. I think we still have some leverage with the decision that it has to be the property has to be merged with the roads. So between that and the 15 grand, I think we've got everything we need.
Lisa, did you have any?
No, I just want to make sure that there was a stipulation in there that she has to buy the property.
Yes,
right?
it's in the decision.
It's in the decision. So if for some reason they say they want 100 grand for it, you can't say, well, I don't want to buy it now.
Mm-hmm.
Just
Okay.
making that clear. Other than that, I don't have any issue with that in the decision.
Okay.
Was that a motion, Lisa?
I can make a motion if everybody's.
Let me just see if there's anyone. So Jeff, did you have anything on this one, or Mark? Or Mark? Sorry.
I don't want to go against the board, and I don't want to seem like a wet blanket today. But we were all really, really clear, and we understand that it's been held up, but Miss Yates did have a buildable lot to begin with. She asked for our relief so she could maximize the program on that lot. And that's fine. And she came to us for relief, and we gave her relief contingent on getting this yard sale property. So, I mean, I'm sure it's going to happen. It's unfortunate it hasn't happened. I'm worried about precedent. I mean, even, Eleanor and Jim can say that precedent really doesn't matter. Well, it does. We're going to get, we're going to get applications now to allow for building using, property that people don't own. And, it's going to happen. So I'm just, those are my feelings on it. But again, I'm only one. And
I'm sorry, I didn't hear that.
it's very unfortunate that's going on.
Yeah, as we said at the last meeting, I mean, Linda, she has built on property that she owns. The only question is the setback from the paper street. And the required setback's 5 feet. Once she gets the paper street, she'll have, I think she'll be like 12 or 13 feet from the paper road. And I get it. I hear the
I
whole
understand that, Mary Ann. I totally understand that, but she just doesn't have the property yet. I mean,
and she's doing everything in her power to get it. Town council's working with us to get it. It's part of the yard sale process. That's why the town took it, so that they could turn around and sell it back to the abutter and get it back on the tax rolls. And that's what we want to do.
Absolutely in writing that she has to buy this piece, no matter what the cost.
It's in the decision that says if she doesn't buy it, the property will be deemed non-conforming, and you can take her CO back. She won't be able to sell or do anything with the house. She won't be able to live in it. There were several conditions in the decision, and we're willing to stand by that. We'd love to get a CO. We would do anything to get a CO, but the problem is we cannot get it because of the holdup at the land court, over which we don't have any control.
Not willing to move into the property without a CO, like probably 20% of the properties on Nantucket are occupied.
Yeah, I don't think any,
I don't, that's not the way to proceed. We want to do, we want to get a certificate of occupancy for the property.
I think the only frustrating part of it was that in order for her to meet the setback, it would have been a very minimal architectural change. And so that was the frustrating part of the original application, was it wasn't, she, maybe had to narrow a room by 3 feet. It wasn't a huge architectural change. So I think that's why it's sort of frustrating. I'm willing to go along with the board. I agree. It's hard to have her held up for this, but she could have completely avoided this by making a small architectural change to her house and not been in front of the board at all, not have this issue of not being able to get her CO.
Right, but the building's there. None of us knew about COVID, frankly. Had we known about it back then, it would have been a different story. And that's really what's driving this whole delay, unfortunately.
Yeah.
So, I mean, if you could, amend the decision to require that, she could get the CO, provided that she puts in escrow funds sufficient, $15,000 to enable the transfer as soon as the town's ready to transfer it.
Is there anyone from the public who wanted to speak about this one? Is there anyone else that we have on here? Whoops. No.
I have a suggestion.
Sure.
Let me see how I can say this. Can we limit the can we prohibit the sale of that property until it gets until that land court parcel has been transferred?
Well, she can't sell it. I don't think she can sell.
To be able to sell it with a certificate of occupancy.
Right.
Oh, you're saying if we say she has a CO and then she goes and sells it. I mean, she could sell it without a CO for a cash deal. If there wasn't a lender.
Yeah, this whole thing of, selling and living without a CEO is not the best idea in the world for my client. You're asking to do something that's not legal. But there is the decision.
That's not exactly right, Mary.
The decision provides that if the yard sale property isn't purchased, then the house would be deemed non-conforming, or the lot non-conforming, because it doesn't meet the side yard setback. That would go with the property, that decision. Linda's not planning to sell it. She's going to live in it. But what happens if Linda drops dead tomorrow, or if Linda all of a sudden needs to sell that property or mortgage or do something with that property in order to realize some funds? I would hate to put you can never sell it restriction.
I wouldn't say never.
I don't think it's enforceable.
I'm not saying you can never sell it. I'm just saying you can't sell it until the yard sale transfer has taken place and she actually has a fully conforming lot.
That seems reasonable.
I don't think that is reasonable, frankly.
Why?
That's an extremely unreasonable restraint on alienation. And I don't want to talk about an appeal because I think we're almost there, but I just, to say to someone, no, you can't do anything with your property, that's a highly unusual restriction to put on property, especially in a zoning matter.
But then you're asking us for us to let her get a CO that violates the setback restriction because we're counting property she doesn't own as property that's hers. So I think
you're not counting it. You're not counting it as hers. You gave her the variance to have, to build what she built. Unfortunately, we're having trouble fulfilling one of the conditions because there is a situation over which my client has no control. And that's the holdup at the land court. I mean, Eleanor's told me that. Vicky Marsh has supported that. The chief title examiner at the land court is sympathetic to us as well. But it's just the process. It's just how the wheels turn. And as I said, we want to buy it. We know that we have to buy it, but we can't buy it until the town has it available to sell it to us.
So what's the pleasure of the board? I mean, I see both sides of it, but I like, Marianne, how you're saying like, oh, it's the process and it's how it goes, but this is our process too. Like, so we're being asked to compromise our process and our standards. And so it's tough. I think if it
is tough, Susan, and I agree with you, but we're compromising too. My client's putting money into escrow. For fingers crossed that she gets to close on this. And as I said, the order could issue in 2 weeks, but it could also issue in 2 or 3 months. I don't know when that's going to happen.
No, I know. It's so tough.
Susan?
Yeah.
I have a question for you. Has anyone approached the building commissioner for a temporary CO to occupy?
No.
I mean, because this is only a land deal we're talking about. If the house has passed muster on all its inspections and everything is valid in that house and it meets the building code standards, why can't he issue a temporary CO?
Because the variance says can't issue a CO until the yard sales happen. If you want to change the condition to say that they can,
It doesn't say a temporary certificate of occupancy in this decision. It says a certificate of occupancy. We can mince words all about it. I'm just trying to look to see if there's an out, because this shouldn't be going on like this.
You want me to see if we can get Paul back on the call?
Either back on the call or a meeting tomorrow.
Let me see if I can get him. Hold on.
Thank you. That would, I think, be
it's an out for us, and it's an out for.
Now, a month ago, I asked if the house was complete, and I was told that it was complete, but you still haven't got everything signed off. It's not in front of Paul for a CO yet.
The interior of the house is fully complete. They had trouble
I'm
getting
sorry?
Victor to come over and do the driveway apron.
But you said that was in now.
That's done. He was there this week. I drove
All right.
by and saw them.
We have some wiggle room to deal with him now that we didn't have before.
With who, Victor?
No, with Paul Murphy.
Yeah, and Jeff Morash was there the other day and said, yeah, just get me the stuff. And
There's been a final inspection done. There's an as-built plot plan that shows the apron, that shows everything in place.
That's all
done.
being filed with the building department this week.
Package is in front of Paul, basically.
No, not yet. It's going to be in front of him.
I need to read the bylaw to you, just so you understand. And this is not the request that came before us, so I feel a little uneasy with this personally, but I don't have a problem with the basis of it, but it's not part of the request. But at any rate, under 139, I'm waiting to hear from Paul. 139.26 D. No, I'm sorry. Is that right? Oh, I lost it now. Hold on. I had it.
On the B.
139.36. Just looking at it. Here we go. H. Temporary permit may, upon written request of an applicant, be authorized by a favorable vote of at least 4 members of the Board of Appeals for a non-conforming structure or use, which the Board of Appeals finds necessary to promote the proper development of the community, provided that such non-conforming structure or use shall be completely removed upon expiration of the permit, unless previously made conforming or validated, without cost to the town, unless the town is the applicant. Such permit may be renewed annually for an aggregate period not exceeding 3 years.
Eleanor, where's the section about COs that talks about temporary COs?
That's what I just read to you.
That's
Well,
all
yeah,
it
you're right.
says?
Oh, hold on. Occupancy. That's temporary permit. 139.28. Temporary occupancy. It's under C. 139.28C. Temporary occupancy for use and occupancy of any building or structure or part thereof during a period of construction or alteration. The building inspector may issue temporary certificates for periods not exceeding 6 months. Oh, Paul, good. Here's Paul.
Okay, so how about if we change this to say, this is the condition, all right?
Wait, we need to bring Paul up to speed because he doesn't know why he's here. So Susan, I'll let you brief him.
Okay. So Paul, we're talking about, this is an application from Linda Yates. She's at 21 Darrymore Road. She had a vacant lot and she built a house upon it. There's a adjacent parcel that's part of the yard sale program. It's been lingering in land court for a while, longer than a while, waiting to get approved. Right now, the structure is non-conforming to setbacks. It will be conforming once she purchases the yard sale parcel. But the condition is that she cannot get a CO until she gets the land court, she has the yard sale packet, the yard sale parcel purchased. So Marianne and Linda are here asking for relief from the condition in the decision prohibiting the CO. They're trying to get a CO. So Mark Poor just said, why don't we look at a temporary CO so she can go in, occupy the premises, and then she can get her real certificate of occupancy once she has purchased the yard sale parcel and is conforming. And we thought to bring you in to see if that's something that you can educate us on or see if that's an option. That's a lot of information I just threw at you.
Yeah, I mean, so it's a little tough for me because if it's in violation of the zoning bylaw, it's a little tough to issue an occupancy permit on that, but I can issue a temporary occupancy permit typically, for anything that's in substantial compliance with the building code or the zoning code. I don't, really know all the facts, but I get it. I mean, obviously what's the time frame on the purchase?
There is no
Does
purchase.
anyone know?
We just
I'm sorry.
There is no purchase, Paul. Mrs. Yates would, everything should be in your office this week or for a CO. But because there's a condition in this variance that says you can't issue a CO until the yard sale has happened, arguably you can't issue one. And based upon the temporary CO language in the bylaw, I'm thinking that what we would do here to address this is change the condition, okay? Eleanor, just listen to how I'm reading, and it will say, rather than what it says now, it will be cured before a CO can be issued for the work. It would say the nonconformity shall be cured before a final, add the word final, certificate of occupancy can be issued for the work contemplated under this decision, semicolon. Notwithstanding the foregoing, nothing herein shall prohibit the issuance of a temporary certificate of occupancy for the structure while the yard sale is pending.
Yeah, I'm fine with that. I mean, this is being conditioned by the board, and all eyes are on it, so it sounds fine to me. I have no objection to issuing a temp.
That work for the board?
That works because the way I put the legal at it was you were requesting a modification.
Right. And that's why I posed it in that way. We're modifying the condition with that language.
Yeah, you said eliminated or modified as reasonably necessary to allow for the issuance of a CO prior to completion of the long delayed yard sale transfer. So I think that works.
I agree. I have no objection to issuing a temp.
Great. Thank you, Paul.
I think,
Okay. Thank you.
Thank you, Paul.
Okay.
I think that's a much better option for this one.
Okay, great.
Doesn't set a precedent as far as I'm concerned.
Yeah,
That's what
great
we
idea, Mark.
avoid.
And Marianne, you say that package will be to Paul this week with?
Yes. Well, they're not open. The building's closed, but it'll be there.
Okay, well, whatever.
I guess we can put it in that box outside.
Yeah.
Yeah, the
Do you still want the escrow or no?
Oh, no.
I don't think we need
still
it.
want escrow, yes.
You do?
Jeff.
Yes,
Yeah, I mean,
absolutely.
Okay. Yeah. Linda, is that all right with you? Still do the escrow?
Yes.
Yes.
Okay.
I pay
All right.
good interest in my escrow accounts.
Okay, so does, who would like to make that motion? Anybody?
I'll make the motion.
Okay, can Mark make that motion? He wasn't at the table.
No, he cannot,
No.
unfortunately, although it was a great idea, but no, he wasn't technically there.
Okay,
No.
so it either has to be Lisa, Michael, or Karen. Can one of you make a motion?
I'll either make the motion or second it, whichever anyone prefers.
you've made it. I'll second it.
Second.
Okay, so just to be clear, it's to modify the condition that the way that Marianne read it, and then to also add an escrow to be held by Reed, Gullickson, Hanley, and Gifford in the amount of $15,000 for the purchase of and whatever associated fees for the land bank, the parcel.
Correct.
All right, so-
Temporary CO have any kind of a time limit on it, or does it?
Well, it's a 3-month time limit on the certificate when it's issued, right?
I thought it was 6 months.
No, it says the building inspector may issue temporary certificates for periods not exceeding 6 months.
There you go.
Then you can renew it for 3 years.
You can renew it.
Yeah.
It can be renewed.
Hopefully, we will have the yard sale parcel well before that.
Okay.
Nothing would give me greater pleasure.
Yeah.
Nor Linda.
Yeah. So, all right. So, Michael, you made the motion. Karen, did you second it?
I did.
Okay. So I'm just going to go down my list then. So Susan McCarthy, aye. Lisa Botticelli,
Aye.
Michael O'Mara,
Aye.
Karen Kosatek,
Aye.
Jeff there.
No.
Okay. Okay, so that motion passes. Okay. Paul, thanks for jumping back on for that.
Sure, no problem. Happy to help. I'll see you guys later.
Okay,
Thanks,
thanks.
Paul.
Thank you very much.
Okay,
Thank you.
you're welcome.
Okay.
Okay, Okay.
I'm gonna not sit on the new business since I'm not gonna be here in December.
Okay, and Michael O'Mara has a conflict on this one too.
So who's my board?
I have at least a perceived conflict. My office, not me, have done rentals at this property in the past. No ongoing business, but if you can raise 5 members, you might as well count me out.
Okay, I think.
Do you have a financial interest in this?
I have a 4:30 call that I have to get on, so I don't know if this is going to go right.
We have to be off by 4:30 anyway.
All right, so let's get going. So we've got
Yeah,
Jeff.
so I'm out of here at 4:25 then.
Okay, we've got myself, Ed, Jim, Jeff, and Mark, right? So, and Karen. We're good. Okay, so so this is 2520 Gunnar P. Wilmot, 3 Summer Street, Marianne Hanley presenting.
Hi, Marianne Hanley on behalf of the applicant Gunnar Wilmot, who's also on with us, as well as Ethan Griffin, our architect. What we are asking for here is a special permit under the bylaws section 13933A in order to allow for to extend the existing side yard setback at about, what is it, 6.7 feet, Ethan, or 6.9 feet? I think you have in front of you the existing and proposed plans. And as you can see, under the existing plan, the side of the house is right on the lot line. This property is located on Summer Street next to the, oh, I'm going to get this wrong now, Baptist. No, what church is that? It is the Baptist church, isn't it?
Yeah.
Yeah. And then there's also a house on the other side of it, which oddly enough doesn't show on the assessor's map, but it's definitely there and you can see it on the plan. That property at 5 Summer Street also runs right up along their lot line. What Mr. Wilmot's trying to do is basically extend his kitchen inside. When you walk into the house, it's a small dwelling anyway. It's 936 square feet, and the kitchen's fairly small. The water heater takes up most of the storage space in the kitchen. The house is on a slab. There's no downstairs. There's no place to store things. So basically, what we're going to try and do is just pull the kitchen wall out 6.5 feet, and still have the storage shed in the rear, so that they can keep, what I saw in there were golf clubs and bikes and, you know, the usual thing that you put in a storage shed. The property's been in the Wilmot family for several years. Mr. Wilmot bought it from his father's estate when he died several years ago. It's kind of an interesting property. It used to be part of 92 Main Street. And if you see the stone steps, that's what connected the two properties. And Gunnar, you can correct me if I'm wrong, but I believe this house was originally used as the stables, and then the cars were parked there. There was a 2-car garage there for a while, and then it was converted into a not a guest house, but just a housing. I think it was housing for staff. In addition to the application materials, I think you have in front of you a photo that Ethan was able to bring up from, what was it, 1890, Ethan?
Yeah, I think around somewhere around the 1880s.
Or 1900, and it shows that there was basically, oh, here it is. And so you can see, there's the church, the Wilmot house is right next to it. And at the back, there was I think it was the area that they pulled the carriages in. So that, can you put that up a little bit, Eleanor? Oh, perfect. Carriages, and then it appears there was some sort of a sitting area on the front. It's hard for me to see exactly what it was, but basically what we're proposing would be pretty much a similar of size, although I don't know, that car thing could be a little wider, or the carriage house. I should know, but I don't know how wide carriages were back in the day. So there is a letter in support from the neighbor at 5 Summer Street. We haven't heard anything from the church, although I know Mr. Wilmot did speak to their caretaker and they are aware of it. They also received their notifications. Most of the addition will be difficult to see from the street. The house is on the right side of the property, and then there's a gate with a fairly thick privet hedge. So it's fairly well hidden from the roadway itself. I don't know if you have any questions or if that sort of wraps it up. This is what this bylaw was made for.
Ed Toole?
Yeah, Marion, is it a one-story addition?
Yes, it is a one-story addition. I believe it's proposed that there's an opening from the upstairs bedroom so that there's some sort of a sitting area similar to what you saw on the old on the historic photo. But Ethan, you can address this better, but I know that Historic Structures Advisory Board has looked at this and we're getting through HDC. We're almost there, but we were HDC bombed or whatever happened, and it's been postponed a couple of times. Ethan, can you tell them a little bit more about that?
Sure. So we've been to HSAB twice and HEC only once, unfortunately. The feedback from Historic Structures Advisory Board was there really no concerns with the massing. They were just wondering if they could see some of the changes on the second floor from the street. And at the last meeting this week, they determined that they really can't see anything. If they could, it'd possibly be from Main Street between I think the Hadwin House and maybe 92 Main, but their concerns were really limited. Again, they didn't really focus on the massing. They thought that was appropriate, especially given the pictures of the historical precedent we provided. They just were worried about the second floor visibility.
And how do you propose to do the work at the zero lot line?
So it would need to obviously be retained right at the lot line. We'd probably, I don't know, we'd either look at doing a slab with integrated footing or a frost wall with the toe of the footing biased fully into the lot. So it'd probably be more like a retaining wall style footing jutting into the lot, so we wouldn't be infringing on the property line as it goes into the ground.
I think we've been fairly consistent in these matters that we asked to see some sort of protocol ahead of time. And I don't see anything like that.
Do you mean construction protocol?
Yes.
Yeah, nobody asked us for that.
Well,
we weren't. I mean, I had talked to Ethan about it. I said, I know that they will probably ask you at the meeting, but.
Right. So I don't think it's our job to ask for what we need to, but anything downtown over the past 10 years, I would say at least, if you were going to be this close, I mean, you're on the lot line, never mind close to the lot line. I also think you need to get some sort of written permission from, I think it's the church, giving you permission to access the property to do your work. So,
oh, absolutely. We would have to get permission from them. We can't go on to somebody else's property without their permission.
I'm aware of that, but I would like to have that as part of the decision.
You could make that a condition of the decision.
I would like to have that as part of the decision before we bother to grant the decision. I mean, it's the same thing that we ask everybody of.
So you want like a letter from the engineer outlining?
Yeah, I mean, again, you can look at any of the past cases where sometimes it's a renovation where we've asked that the old foundation stays in place. Sometimes it's a new portion where you're going to have to excavate and overdig, possibly. But we don't know. We don't know how you're going to do it because you haven't provided us with any information.
And then don't we also ask for to make sure that whoever's doing the work, that the neighbors have the cell phone number, so if there's an issue?
Yeah, you have the GC contractor. The cases, I know exactly what Ed's talking about. I can think of 5 off the top of my head, but there've been The most recent one was John Brusher's client, and they provided this massive set of exhibits up off Cliff Road.
Mhm.
You may recall with the construction protocols, that was sort of a similar project, but they were lifting the house up, if I recall, putting in a whole new foundation underneath the whole house, the whole front L of that particular house. But I know what Ed's talking about. There's construction protocols that are conditions that are tacked on at the end.
Ethan, does the size of this project even trigger any sort of notice to the neighbors?
In terms of butter notifications?
Yes.
Well, because it's in the OHD, it's technically over 100 square feet. So we did notify abutters for the HDC process. And I believe for this process as well.
Yes, yeah, the abutters have all been notified with this process as well.
In terms of just the methods of the construction, I mean, we're talking about kind of retaining one wall that's about 6'6" on that property line. So really we'd be forming it essentially in place up against what we're using to retain the material along the property line, and leaving that essentially in situ, in perpetuity once the wall has been formed. But we could certainly provide a construction detail that outlines that. In addition,
I'm a little confused. You're going to use a one-sided form? You're going to do some sort of a shoring?
Probably leave that one side in place once it's formed. So, there's
won't that one side be on the church's property?
It would be on the property line.
It looks like it would be, I have to agree with Mr. Thayer. It looks like it would be on the church's property.
Looks like your foundation wall, your structure is on the property line. So consequently, whatever you use as a one-sided form will be on the church's property.
In so much as that, so right at that intersection where the corner of the house is, the property line actually sort of takes a cant. It doesn't continue straight. So there's a natural sort of joint there. So wherever that formwork needs to be, so it's not on the church's property, that's where it's going to be. And then the shingles are going to be stitched in. So that wall is actually not orthogonal to the existing wall of the house.
Okay, I believe you, but I think we need to see that.
I'm a little bit confused, and I think that I think you've got to get permission. I mean, regardless, you've got to get written permission from the church to go on their property. You're going to be working on their property throughout the whole thing. Just carpenters are going to be walking around on there. And we've asked for this for the last 5 years. We've asked for this stuff before we render a decision.
Right.
Okay, so it sounds to me like we need to continue so that these guys can put together whatever their packet is going to be, and maybe reach out to Eleanor and she can give you direction on what we've received in the past if you have any questions. Does that sound reasonable to everybody?
Gunnar, do you have anything to say?
Up, you're on mute.
You have to unmute.
Okay. No, I think this is fairly reasonable, and I think we can come up with this fairly easily. I did go over to the church. By the way, on all the maps, it's the Baptist church, but they changed a few years. I think it's legally still the Baptist church, but they changed a few years ago to the Evangelical church. And I went over to try to explain to the pastor what we were doing and to get his point of view on it and to answer any questions he might have. The church is between pastors, but they have an office of elders. And the guy that I spoke to in the church said, just let the process run its course. And if the elders have any objection, they will voice that objection once they get the notice. They've had the notice. They haven't voiced any objection, but I will go see them. The church office is on Trotter's Lane, which I believe is off Fairgrounds. And I'll go over and see what I can do. And they're good neighbors. I'm a good neighbor. I'm sure I won't have any problem getting their written permission to have carpenters walk on their property while we build this thing.
Jim?
I just have a question regarding that HDC approval. Is it still in process, or I saw there were notes in there?
Correct. It's still in process. We're on the agenda for this coming Tuesday, and hopefully they'll get to us. It's just been kind of getting kicked down the road.
Yeah, I actually talked to Holly about it while I was doing my staff report. Holly Backus, who is the administrator for HSAB and sits in on all the HDC meetings. And she explained that they were on the schedule for the other day, but there was such a packed agenda, they didn't make it to it.
Okay.
Okay. So do you want a motion, Susan, to continue to the next meeting?
When is the next meeting?
The 10th of December. Oh,
And when would we just make sure we've got the materials, the supplemental materials? When would you guys need that by for the meeting?
I'm literally sending you some samples of decisions that were issued with conditions right now. So you'll get those after we leave the meeting. And I would want the materials to be posted with the packet no later than December 4th, please.
Oh, yeah, okay, no problem.
I'm not gonna vote on this one because I just realized December 10th I might have a conflict. We didn't continue anything else, right?
Well, we have the sales matter.
But I'm not sitting on that one.
Okay.
So I'm not gonna vote on this one, but just in case I can't be here for the December 10th.
Well, then Ed will run the meeting, I guess, since Lisa's probably not going to be there, nor will you.
Okay, Ed, right back at chair.
So that still leaves us with 5 members.
I always wanted.
Moving on up, moving on up.
Can I make that motion to continue to next week, to next month?
Yes, and who wants a second?
I'll second it.
Okay, so I will. So I'll do a roll call then. So Ed Toole.
Aye.
Jim Mondani.
Aye.
Jeff Thayer.
Aye.
And Karam Kosayatek.
Aye.
And then was that only 4? Yeah, Mark Poor.
Aye.
Okay, so sitting on this one next time is Ed, Jim, Mark, Jeff, and Karam.
Great, thank you very much.
Okay, thank you.
One more quick thing to vote on the schedule, that's all.
Yeah, no, I was going to say for other business, did anyone have any comments on the schedule for next year?
No.
I didn't. October 14th is the week following Columbus Day, so that's fine. And
I could never look that far ahead.
I just was trying to look and see if there were any conflicts with like holiday weekends or long weekends or something like that.
Not that you can go anywhere.
Not that you can go anywhere, but just in case.
Well, just plug the dates into your things, your outlooks and so forth.
July 8th is my birthday, so I won't be here that day.
July 8th is.
Why don't we celebrate your birthday remotely?
May not celebrate my birthday. I'm just
I always put them in my calendar, but then I never check my calendar when I'm making other plans.
Isn't it still the second Thursday of every month?
It is, except for November, because that is our Armistice Day is the second Thursday in 2021.
Lisa, you never check your calendar when you're making plans?
When I'm making plane reservations.
Maybe you need a secretary.
I don't know. I just sort of was like, oh.
What if you have like appointments and stuff? All right, well, whatever.
I have a little, I do it the old fashioned way, big book.
I have a book too, but all right.
But
so
I never think about, unfortunately, and I apologize.
All right, so other than Jeff's birthday on July 8th, which we won't be able to celebrate and sing happy birthday to him since he's already said he's not coming to the meeting, are there any other conflicts? No. All right, so we just make a motion to approve the calendar as drafted?
Yes, please.
Who wants to do that?
I'll make the motion.
Second.
Okay, so motion's made and seconded. So do we have to do roll call for this one too?
Yes, please.
Okay, so myself, I, Michael O'Mara.
Aye.
Ed Toole.
Aye.
Hiram.
Aye.
And Lisa.
Aye.
Okay, so that motion passes. Here's our new calendar. Make your notes. All right, I guess that's it for this month.
Okay, thank you.
All right.
Motion to adjourn.
Oh yeah, motion to adjourn.
Thank you.
You.
Second.
All right, that's Karen's job. Karen always does that.
Do we have to roll call that too?
Yeah. Let's cover our
Mike,
bases.
I,
myself, I. Mark Poor,
Aye.
Jim,
Aye.
and Karen.
Aye.
All right, great job.
thank you.
Okay, thank you guys.
Thanks.
Thank you.
Have a
See
great night.
some of you next month.
Okay, bye.